Railways. Yes. Maybe will 28th tomorrow. Serve. Give. When will you be evicted? Any date fixed?
There's also one solicitation case. I have given 5 times. I have not been granted that many days. So that is the reason why I'm moving it. I have asked them to run with systematic stock. I'm not running, but they're taking to demolish myself.
But they'll go for new fresh auction, isn't it?
Even share the there's no auction is coming up.
Very well. So, what is the urgency? There is no urgency.
Demolish my stock. I have manager is not.
Where is your matter?
Running in the business.
What is daily list or month 292?
ছোট দেখাও তাহলে বেশি
জানা বাবু জানা বাবু দুটো আইটেম আর্জেন্ট মোশনে দিয়ে দিন 31st Friday. No, don't mention for inclusions and upgradations.
Lordship, kindly, Lordship.
No, please.
Lordship, two matter, Lordship.
This matter was good. This matter was 5, and it was good. And the petitioner said that we will grant us leave to move before the vacation. Before the vacation, what they did, they took again and leave for doing it before the regular. There are mentioned. What happened, my lord?
You are for the respondents.
Respondent, why, my lord? It's my bank account. Now, bank is not allowing me to operate it, and there is no one, my lord, filing a matter in a similar matter against the UCO bank. It was filed by her, and order was passed rejecting her. For that, my business had come from. That's why.
There is no order of the court.
There is no order of the court.
Then?
Fact is saying that it's pending, so I will not allow you to operate. The moment the matter goes by, I want that the hearing be done.
So hearing, the court is hearing matters, not that the court is not hearing.
Matter, that's why I have come for upgradation.
Don't. Yes.
Permitted to mention a matter for upgradation item.
No, please. Don't mention.
My lord, one matter, my lord, what has happened in 1980?
I don't want to hear.
1980
upgradation.
My lord, upgradation.
Sorry.
Lordship, one matter of Jalpaiguri
application for registration of exotic birds has been cancelled. Your ladyship has been pleased to take up a similar matter. Exactly same, only information of rejection given, order not even given to me.
Yes.
So, your ladyship, I pray for your ladyship's leave. Ladyship has been pleased to keep the matters on 29th. If these are also placed together, this matter.
Very well. Give.
My lord, I have also similar prayers, my lord, same matters, my lord.
Exotic birds?
Yes, exotic birds, my lord, similar orders.
Where is the file? Where is it running in the list?
Yes, it is running in the list.
Item number?
Lord, item number 1 is 145. And
Daily or combined?
Lord, combined list. No, daily monthly list, my lord. Daily supplementary.
Daily monthly?
Sorry, my lord, sorry, I'm sorry. Daily supplementary list.
145?
145 and my lord 272 to 277. No, these are all placed on 29th for your consideration.
29th. একসঙ্গে দিয়ে দেবেন.
May I have your lordship's kindly. My business accounts has been, my lord, freezed.
Upgradation or inclusion?
My lord, this is my lord 310 of your lordship's list.
Please
but
come next week.
My business account has been freezed without any intimation or my lord.
Cannot be helped. Yes, madam.
Lordship, may I permit?
The matter, it is an upgradation, but my bank account, which is a business account, without any reason, simply on the ground of suspicion, it has been.
Please, next week come.
My lord,
Lordship, may I permit?
And may I mention, my lord?
Last Thursday is the last date for submission of bids. Where is the problem?
If tender committee selected any person, then another problem will get.
As of now, no problem. Nothing doing. Yes.
Very urgent motion, my lord, my land and my property, which is of 10 acres, is being taken over by the state without any notice, without any proceeding. They are trying to move in the heavy machineries and they are trying to take possession of my land and
State means which department?
land department as well as the health department
All right.
pertaining to land lordship. I am praying for your lordship's leave to move this matter on any day, subject to your lordship's permission.
Very well. Today is Monday. Give notice. Thursday it will appear.
Lordship, may I be,
I'm
Lordship, may I be
Serve
Lordship,
notice.
may I pardon me?
Urgent
Lordship,
motion. Urgent motion. Give leave.
Give the purpose.
Yes, leave.
kindly allow me to mention two matter, Lordship. One matter of Jalpaiguri Circuit Bench, Lordship. I had already
Inclusion in
mentioned
the
3
list
times,
you
more
are
than
filed
3
for
times. Lordship, may I audible?
No. Date of the order?
Order dated on 3rd October, the matter will appear on 21st November.
Yeah. Why are you mentioning now?
But the matter is not appearing in the.
When inclusions will be taken up, then mention. Yes.
Lordship, may I audible? Lordship, may I audible?
Another country is there of the only the function is another construct under
1962 Act. Which bench has determination? Code
Lordship,
number
may I-
17. Which honorable court judge? Justice Sengupta, 163. 163. 1962 Act. Item number
2106.
of 2106. Release for want of determination.
Lordship, may I
The order is being passed. Put in your appearance. Yes. No. Second of February. 30th of January. Item number. Justice Roy's list. Very well. Thursday, urgent motion.
Lordship, may I be
1 minute. Yes. You want inclusion or upgradation? Come next week. Non-prosecution, hand over the slip.
one matter for inclusion. Milord, what happened, Milord, the FEMA authorities
Please
have
come next week.
some urgency, Milord.
What is the urgency?
Milord, their statutory appeal has been preferred, Milord, very recently. Milord, they are proceeding with the execution. That is the whole difficulty.
And proceeding with the execution doesn't mean that the execution will take place immediately. Then please wait.
My lord, leave may be granted to move an urgent application of Justice Roy's list, my lord. Lord, urgency, my lord, in spite of interim order, the respondent number 2 put my sand block into auction, and in the tender process, the document or submission of documents has already been closed. Any day, the block can be allotted between the successful bidders, my lord.
And who are you?
I am, this is my sand block, my lord, that has been allotted to me.
But then your lease has expired.
Lease has expired, but there is an interim order, and that is still subsisting till 31st March 2024, 2025.
Very well. Thursday it will appear. Serve notice.
Grateful, my lord.
Mention lordship one upgradation lordship. This electricity matter entire bidding of the petitioner is without electricity lordship.
Let it remain. Cannot help.
Lordship, essential commodity.
Sorry. Yes.
An urgent motion, your lordship. The petitioner participated in an auction for extraction of sand, your lordship. In spite of being the highest bidder,
Where is the matter?
it is not in the list, your lordship.
You want inclusion? You want leave?
Kindly takes up the matter. The successful bidder may be announced any day. The bid was closed on 24/1/2025, your lordship.
And did you participate in the bid?
Yes, and I was shown that there were some technical glitches, so I was excluded from that list, your lordship.
Very well. Thursday.
Lordship, may I be permitted to mention one matter? This is a tender matter, your lordship. And the payment is still pending for the very long time, your lordship. Lordship, this is a tender matter, your lordship, and the payment is pending for very long time.
Tender matter payment.
Yes, Yes, your lordship.
How tender and payment go
Yeah,
together?
the laborer's payment is still pending.
So you've concluded the work, you want payment?
Yes, sir.
No.
My lords, may I be permitted to, my lords, mention?
To leave for my lord filing on his application, my lord, the physical possession will be taken at any time, my lord. Symbolic possession has already been taken, my lord,
By
by the bank authorities, my lord.
surfacey?
No, surface, under surface act, my lord. But my lord, what happened, my lord? The bank authorities marked my credit card limit with my lord, home loan, my lord, illegally, my lord. My lord, let it be taken up at any day, my lord, my lord. Within my lord.
You go before the tribunal. What is the use moving before this bench?
Without maintaining any rules and regulations, they have filed.
Very good ground. Why don't you go before the tribunal?
Let it be our stay onward.
Thing is, you won't get any relief. Unnecessary time will be wasted before this bench.
Without maintaining, following the rules and regulations, they have
So the tribunal is the proper authority to hear the matter.
my lord has passed on.
Why this writ court?
Since they have not followed the Reserve Bank rules and regulations, also,
Yes, so that is a good ground for moving the tribunal.
let a order be passed, my lord. Otherwise, my residential accommodation will be, my lord.
You are not trying to understand. You will not get any relief. The court is not granting any relief. The law does not permit the writ court to enter in all these type of disputes. There is a specified forum. Go over there.
My lords, may I
Leadership, with your kind leave.
take your lordship leaves to file this, my lords, writ petition. My lords, this is regarding the determination of Honorable Justice Aniruddha Rai relating to my lords land. My lords, I am the owner of a, my lords, shop room on the basis of, my lord, the purchase deed. My lord, the PWD on 25th January, my lords, announced in the locality that my shop room will be, my lords, demolished in, my lords, 30th January. No notice has been issued. No, my lords, opportunity of hearing has been given.
Give
My lords,
30th,
With your lordship's leave.
30th serve notice.
very well.
Your lordship, with
Extension of interim order.
your lordship, with your kind leave, may I mention?
I am not hearing. I am not upgrading. Yes.
Six matters. Since there is no 40 days notice, the office of the learned government leader has refused to accept service.
Why are you mentioning?
Lordship, since the matter is already running in the list, unless an order is passed from this honorable court, the office of the learned government leader won't accept service. I'm
Since
only for a direction to serve the government.
certainly not. Why will the GP office not accept service? All matters they are accepting.
There is no clear 40 days notice, Your Lordship.
What is the urgency?
Lordship, the urgency-
Where is the matter?
It is running in the list, Your Lordship.
So why do you serve notice 48 hours? It will be taken up after 72 hours.
Lordship, may I mention, my
Lordship, may I be? Please wait. Yes.
Lordship, on 13th of January, mother, your lordship.
What do you want?
My lord, item number 46 and 47, mother, of your lordship's list, my lord. It is appearing as an adjourned motion, my lord.
Yes.
Now, my lord, pursuant to your lordship's direction on 13th January, mother, we have deposited, my lord, 3 crore 26 lakh 51,000, mother. Now, only thing that remains, mother, in the matter is issuance of sales certificate, mother. For that, mother, your
Wait, it will be taken up. Yes.
Lordship, may I be permitted?
No inclusion.
Lordship, may I be permitted to mention one matter under the heading substitution application, Lordship?
No.
May I
Yes.
permitted to mention this is the RTI matter, whatever the
What
information.
is what matter?
RTI, Right to
RTI.
Information Act,
Why are you mentioning? For what purpose?
for upgradation. my-
Sorry.
Your lordship, with your kind leave,
My lord.
it's an urgent motion matter, my lord. This is a grave urgency because the company is under CIRP and the resolution plan is under consideration before the COC. The suspended board is refrained from traveling abroad against their constitutional right, my lord. Purportedly, some lookout notice is issued against them, but we have not been given. We are writing to the SFIO and the immigration authorities. Your lordship, next week we have travel plans. We have annexed in the writ petition. We have already given, served. My lord, kindly take this matter led by Mr. Ratnango Banerjee.
If you have plans to move out next week, it cannot be helped.
My lord, kindly take it up on 29th or 30th, my lord.
Petitioner has constructed his.
What do you want?
Lordship, respondents will remove the construction by today, Lordship. They have
Which
stated,
construction?
building.
Yes.
Petitioner's
Why? Under which provision of law? Under which provision of law? Do not know.
It's a case of activity. ALC has given order in my.
What you want?
I want the 21 is pending as motion.
Cannot help.
Lord, may I have my lord's kind leave, my lord?
One case, the Nagaland state lord, the petitioner owner. From November, in this matter is pending notification. Only first price. Then after that,
You want the money, lottery money. That
Lord,
cannot
may I have
help.
my lord's kind leave?
My lord, maybe, my lord,
Yes.
may be permitted to mention one matter, my lord. This matter is running under the heading of as an adjourned motion, item number 44.
Daily list.
Yes, madam, my lord. The urgencies, the arms is there.
Further.
My lord, kindly allow me this.
Further.
Kindly
It is
fixed
already there.
my lord, kindly
No,
fixed
no
a date.
fixing.
Lordship, may I audible, Lordship? Lordship, may I audible?
Intimation has been given to the Reserve Bank of India that my account is dropped. This intimation is beholds to a so-called notice given to me where I was fixed for a specific date. That is, on the 1st of January. Intimation given on the 30th of December. However, the so-called notice was unilaterally waived from me. I was never given a chance to so-called whether my account is fraud or not. I have mentioned for account. My item number is 283 of the daily list.
Next week.
My lord, may I have my lord's kind leave, my lord, to mention, my lord, item 237, my lord. My lord, here the urgency is, my lord, that I am a woman. I am seeking, my lord, assisted reproductive technology, my lord, which, my lord, I am not being availed of.
Next week
My
come.
lord, I am approaching the threshold age, my lord. That is the urgency. Your lordship
Next
may
week
kindly.
come.
My lord, my case is listed on new motion, and my urgency is that my account has been freezed on 24th September 2024, and is my salary account. I am not even able to perform any kind of financial activity.
Yes, nothing doing.
May I have your lordship kindly to mention a matter, your lordship, tender matter. We have been blacklisted from seeking any benefits, virtually making it impossible for us to place any bids. Lordship seeking upgradation in monthly list, item number 1860.
Next week, upgradation will be taken up mention.
It's really in the nature of an extension of interim order. Interim order expired on November 30. I have taken out an application and let the application be listed.
No infusion.
restoration applications.
No
Restorations of your lordship kindly recollect this. The advocate which has been suspended by the
Next week when inclusions will be taken up mention.
My lord, for release, my lord, group 6 matter.
Which item?
My lord, 1458 in monthly list.
Why did you not mention it earlier?
My lord,
1458.
yes, my lord.
Who is the advocate on record?
MD Nizamuddin Molla.
Where is he?
My lord, he is.
Who are you?
We are both working together.
Are you sure it's not
Yes,
there
yes,
in the list?
yes, ma'am.
1458 released for want of determination. Please put in your appearance.
My lord, allow me to mention, my lord, item number 1049 of January monthly list. One of the private respondent without due process.
Upgradation?
Yes, my lord.
Sorry.
My lord.
Lordship, may I audible, Lordship?
70 years old person, at least gratuity is not getting.
Please come next week.
My lord's kind leave.
PWD.
What you want?
My lord, inclusion is a matter under Justice, Honorable Justice Aniruddha Dotto. My
Yes.
Lord. My land, my lord.
What is the name of the honorable judge?
Pardon, my lord.
Aniruddha Roy.
Honorable Justice Aniruddha Roy, my lord.
Yes.
It's my personal land, my lord, encircled with the boundary wall. PWD marked the boundary wall for demolition of the same under the garb of expansion of Howrah Road. Now, my lord, they have already commenced their work 100 meters away from my property, my lord. By tomorrow or day after tomorrow, my lord, they will demolish my wall, my lord.
PWD will cover up 100 meters within 24 hours. I wish they could.
My lord, 100
I
meters
wish.
away from
Please
my
come.
My lord's kind leave, my lord.
Number 364.
Upgradation? No, sir.
My lord's kind leave, my lord.
Lordship, may I audible?
Contempt
Lordship?
application, my lord.
No.
With your kind
Lordship,
leave,
may
my
I
lord.
audible, Lordship? Lordship, may I audible?
The exercise method during pendency of this happening, my lord. They have stopped my online portal and I cannot log in enter business question.
Yes.
During pendency of this. My lord, only simple frivolous application for the allocation is street building plan. I am last 8 years I have done. Get to year and salesman that is allocation. That is my sales.
We will give Thursday it will appear. Serve. Thursday.
May I permitted to mention one matter, despite lodging complaints to the local police station and distribution agency theft of.
Why do you want, why are you mentioning? Sorry.
Lordship,
Yes.
Lordship,
Matter for inclusion.
No.
Ladyship, for extension of interim order.
Lordship, am I audible?
No. No upgradations.
My lord, may I be permitted to mention a matter for inclusion? My lord, it's a very urgent matter, my lord. The DM is pending the representation by the petitioner bank since 3 years.
3 years, suddenly urgency has cropped up. Sorry, somebody is
Am I
online.
audible? Yes, Lordship. Lordship, one matter I have already mentioned 3 times, Lordship. One matter which was in before the Jalpaiguri Circuit Bench, Lordship. Honorable Justice Aniruddha Roy has transferred due to jurisdiction issue, Lordship. Kindly inclusion the matter, Lordship, the matter relating to the digital non-issue of digital number of the scheduled caste certificate, Lordship. Kindly, Lordship, include this matter, Lordship. The writ petition number 23325 of 2024, Lordship. I had already mentioned 3 times, Lordship, and you had already allowed, but unfortunately it never come in the list, Lordship.
Has the file come from Jalpaiguri?
Yes, Lordship. I already communicated with the concerned department, Lordship. They just said that after necessary order and requisite, they will place the matter before the bench, Lordship.
Janababu, please check. 3 times it was mentioned and the court allowed mentioning.
Lordship, another matter, Lordship.
23325 2024.
23325 of 2020. Lordship, another matter, Lordship, it was already passed the necessary order in the before the vacation bench. Let the matter appear before the regular bench on 1 week after reopening the court following the Christmas vacation, Lordship. Lordship, this was the urgency, Lordship, because the election is going on, Pharmacy Council election, Lordship. Already, Lordship, on 27th, that's the last date of receiving of the voting paper from the electors, Lordship. Lordship, this matter regarding the biasness of the returning officer, Lordship. Kindly, Lordship,
There
include this
possibly similar type of matter was moved earlier.
Yes, Lordship.
And the court has
Lordship. No, Lordship. No, Lordship. It was appear before the vacation bench, and vacation bench passed the necessary order due to.
No, before this bench also similar matters were moved. I am aware of it.
No, Lordship. This is specifically I filed before this bench, Lordship. On first day, you heard the matter, and after that matter was came before the vacation bench. Lordship, the honorable vacation bench, Lordship, directed to serve the
3059 2024 30594 2024 adjourn motion.
But with regard to item number 416,
30595 of
license
2024.
all of a sudden,
30595.
my clinical establishment license all on a sudden has been cancelled by the BOMA without giving any opportunity of hearing.
Yes.
Item number 416.
Next week, I
matter
will
has been mentioned by my junior. This matter was mentioned before your lordship.
Yes. What did the court say?
My lord, your lordship was asked him to mention afterwards.
Yes, afterwards means next week mentioning will be accepted.
And another my lord, 423, my lord. Another 423.
No upgradations. Don't not mention. Next week come.
A notice was issued by us on last Thursday. We filed a writ petition. Wherein 7 days time has been given to deposit 10 crores, failing which the bank account will be attached. This relates to a compounding application in which they took an undertaking that I will not challenge the final order. Now, my compounding application has been returned, and now a notice has been issued to attach my bank account. Under the compounding application, I am required to pay 20 lakhs. The demand is for 10 crores, I am willing to deposit, kindly takes it up any day before Thursday, I filed a writ petition last Friday, I received on Thursday, I filed on Friday, I mentioned today,
Very well, Thursday it will appear.
Wednesday,
all right, Wednesday. Won't your other side serve notice?
I have already served, I'll serve again.
Please serve.
My lord,
Ensure
item number-
that your other side is present.
My lord, item number 483, my lord, 1483.
Sorry.
Upgradation because it is covered
All
by
the list,
the
please.
order of honorable
Lordship,
judge.
only one
matter for extension.
Lordship, one urgent matter.
Extension give.
For inclusion.
Lordship, one urgent matter, Lordship. Lordship, in the days list, Lordship, item number 40, Lordship had heard it on the 15th, Lordship. And Lordship had directed the matter to come up on the next date, but thereafter the matter is not being taken up, Lordship.
Taken up, it's there in the list.
It
You
is
have
there
to
in
wait.
the list, Lordship, but unless and until it is taken up, Lordship, on an
I
urgent
cannot
basis.
help.
Some urgency.
No, sorry. Yes, who is there? Contempt application. Yes.
My lord, on the last occasion, my lord had made an order that the order dated July 12th, 2023, be complied with. my lord, just now I've got a copy of the order, which is a demolition order. Just now I received it, my lord.
And you want demolition to take place?
It has been already dispatched earlier to the concerned parties.
I've taken instruction from my client.
Whatever, you want demolition to take
That
place?
is my lord's pleasure. My lord, kindly sees the third
Then
page.
if the order has been complied with, what remains?
No, the third page of 12th July order that they were required to comply with. Kindly sees the last order that my lord made.
Yes, I
Comply
have
with
seen
the
it.
order
Well,
passed by your lordship for consideration of the matter.
Kindly sees
That
the
has been considered.
That has been considered.
kindly sees the 12th July order. My lord,
Construction as per
that is annexed to the
have
contempt application.
to be demolished within 30 days from the date 15th of January. This order has
Now,
been
now
passed.
the
Now,
PR
12
has to get an opportunity
But-
of appeal.
Then let that be made. Yes.
So how can we comply with
An
that?
affidavit of compliance
30 days
has
time
been
has
placed
been given.
before this court. Annexing copy of the order dated 15th
My
of
lord will kindly
January
adjourn the matter, not
2025,
dispose this of.
passed by the executive engineer within brackets C/building/Borough 6 of the Kolkata Municipal Corporation, directing demolition of the unauthorized portion of the subject construction within 30 days. Stop paragraph. It appears that the order passed by the court has been substantially complied with. Stop. Next. In view of the above, the contempt application stands disposed of. Stop. The party shall take steps in the matter in accordance with law.
12th July order, my lord had said that they will deal with the unauthorized construction.
It has been
Deal.
dealt with.
Disposed.
Deal মানে ভাঙা।
With the application, contempt along with the connected application disposed of.
But to deal with a construction illegal
Yes.
means to break it. Obliged person.
I am grateful to your lordship.
In lordship, in this matter, I am appealing for the petitioner in lordship. Sir, only your lordship kindly, some portion has been demolished, but the entire building has not been demolished, your lordship.
How much is left?
I have some photographs, your lordships.
Yes, let me see. How much is left?
So entire portion, only some portions, your lordship, little portions.
As I understand, my lord,
Yes.
they're proceeding with there's one part. The other part is there is an appeal pending before the building tribunal by the person who has suffered the order of the special
Demolition.
officer. And corporation, in spite of that, is proceeding. My lord, I am a bit disorganized. My lord takes it up next week.
Very well. Please come.
I can give the report.
Give. The learned advocate appearing for the petitioner submits that the unauthorized construction is yet to be demolished. Paragraph. Photograph in support of the aforesaid submission has been placed before this court. Stop. Paragraph. It has been brought to the notice of the court that an appeal has been carried by the person suffering the order of demolition.
I
Stop.
can give the number also, BT appeal number 124 of 2024.
Being BT appeal number 124/2024. Any stay or anything of that
Well,
sort?
as yet, there is no information of any stay.
Very well.
And if your lordship takes my last report,
all right,
the last 4 pages of that report, your lordship would find that the corporation is proceeding with the demolition.
Very well. Paragraph. ওখানে লিখুন যে it has been submitted by the learned advocate representing the corporation that the demolition work is in progress. Stop. Paragraph. On the prayer of the learned advocate representing the corporation, time to file an updated affidavit of compliance is extended till 4th March 2025.
Should I pray for one thing? Your lordship would pardon my impertinence. Your lordship, just instead of saying what your lordship has fallen from your lordship, direct the Pankaj Sarkar executive engineer to file the comprehensive report. Lordship gives 15 days time because next week also this 15 days time along with the photographs.
I'll include the photographs, but
not
then
these photographs. After
what
this, whatever is the
Updated
Yes,
photographs.
updated photographs.
I can
Pankaj
understand.
Sarkar, executive engineer.
নামটা লিখে দিন তো।
Boro 3.
নামটা লিখে দিন, পঙ্কজ সরকার, এক্সিকিউটিভ ইঞ্জিনিয়ার, বোরো 3, বোরো 3। ঠিক আছে, যেখানে আপডেটেড, যেখানে কমপ্লায়েন্স, এফিডেভিট অফ কমপ্লায়েন্স বললাম, সেখানে আপডেটেড রিপোর্ট উইথ রিসেন্ট ফটোগ্রাফস। But then I'm placing it on the 4th of March, giving you some more time. In the meantime, if something happens in the appeal, then that's all right.
Much obliged. Much obliged.
My lord, I beg to appear on behalf of the applicant, my lord. It has come, my lord, after my lord serving the notice.
Has order been complied? No.
So for
What
my
is to be done?
instruction is that
Not
it has not
complied.
been complied.
What
So
is to be done?
kindly, my lord, sees the nature, spirit of your lordship order, my lord. That is very relevant. Sir, আগে বলিনি আমি একটু তারপর বলবো। ঠিক আছে। Page, my lord, 77. Second 78 is very relevant, my lord. The second paragraph, if the aforesaid authority, as your lordship got it, the authority is of the opinion that the further hearing is required to be conducted, then the same shall be conducted at the early date upon the notice to the petitioner. The legal representative of the petitioner may attend the hearing and make submission on behalf of the petitioner. The authority may cause spot inspection upon prior notice to the petitioner to ascertain the inconvenience faced by the petitioner on account of the said urinals. Because it is a public urinal just next to my house. The legal representative of the petitioner will be permitted to remain present at the time of spot inspection if conducted. A decision shall be taken in this matter at the earliest, but positively within a period of 8 weeks from the date of communication of this. This is very vital one, because your lordship says, my lord, after inspection.
What happened? Inspection took place.
Inspection took place. I have a very serious objection regarding inspection. I have also noted it, but I have also sent them no notice that I have my lord, objection with regard to your inspection. Thereafter, my lord, no, my lord, hearing was taken place. Immediately, my lord, they have served this one, my lord, 89. I do not know whether it is a decision or not. Your lordship can be said or decision. Page 89.
89.
No hearing, only conclusion. Inspection report is there. Unilaterally, they have, my lord, inspected on the basis of their report without considering my objection. Conclusion is there. Now, your lordship kindly consider a quasi-judicial authority is making a conclusion without hearing to the other parties.
The page 89 is pretty illegible. I'm
This
trying
thing, my lord, they have sent, my lord, to me.
Started. You have a copy?
Yes.
Please.
That the decision or which has been communicated to him.
That is not the decision. 89. This is not the decision. এটা না এটা না না এটা
ওটা কি দেখাচ্ছে
No, এটা কোন ডেটে দেখুন আগে এইটা
5th of February 2024.
Yes, yes.
This is December 24. What is this? Why reveal said 20 years back?
Second December 2024.
ওটাই দেখাচ্ছিলে
দ্বিতীয় কাগজ দেখলাম
এটা তো আমাদের দেননি বোধহয়
You know, you see the pre-page that was addressed to my land owner.
Yes. Even
they say that the urinal is there for the last 20 years and they clean it regularly.
That is their version, my lord. Their version, my lord. Then, my lord, hearing should be conducted, my lord, as per your lordship order, my lord. My lord, that is there, my lord. The authority is deciding an issue, my lord, without hearing the other party, my lord.
Thing is,
That
what
is
inspection was done?
Inspection was done.
Can I have objection regarding the inspection? They have not noted it.
Inspection, you may have.
What is the objection?
Regarding, my lord, there is a, my lord, common wall is there. My lord, they have also, my lord, inspected the premise, my lord, that urinals Only, my lord.
Where is the common wall? There is a
Yes, sir,
distance
that
of
is the
8
thing,
feet.
my lord. My lord, kindly see
8
the
feet,
for my
4
photograph.
inches.
Photograph.
Photographs and on inspection on everything.
Where is your photograph? Take it.
In the read petition, I am, my lord, annexed.
Please show. Which page?
petition Grievance was more that we have been constructing, where we have near his premises is a new construction, but it's not so. That is the grievance your lordship recorded. The grievance of the petition is that the corporation is constructing an urinal just beside the premises of the petitioner.
Then no use of it, my lord, for passing that order.
This is a new construction.
They will decide it unilaterally.
9 feet. 9 feet. It is your photograph. Five feet 8 inches. Seven feet 4 inches.
That urinal, my lord, to my, as per my information, it was not in use for a
Not
long period.
Maybe not in use, but it was there constructed for a long time. And this is a public.
My lord, kindly sees, my lord, whether it was, my lord, sanctioned or not. Kindly sees, my lord. Kindly, my lord, direct them to the being record. If there is a private, public, no,
utility.
it is required, my lord. The decision is required.
It is a public utility, and if they clean it on regular basis, then what?
My lord, I have, my lord, also, my lord, got information, my lord. There is no sanction of it.
Decide here. The petitioner does not decide in that particular premises.
That's why you can do it.
Different place. But I am not that issue. But the thing is this, your lordship direction was that.
Please come. The learned advocate for the petitioner alleges that the direction passed by the court for providing opportunity of hearing to the petitioner after conducting spot inspection has not been complied with. Stop. It has been admitted that a spot inspection was conducted.
An inspection report was also forwarded to my learned.
An inspection report forwarded to the petitioner is annexed to the contempt application. Stop. Paragraph.
And well, I have also
learned advocate for the petitioner has produced photograph to show the distance of the public urinal from his premises. Stop. Paragraph. According to the corporation, the distance between the two structures is 8 feet 4 inches. Stop. The petitioner submits that the distance is less than that. Stop. According to the corporation, the structure was built 20 years back on public demand. Stop. The same is being cleaned regularly so that the place remains clean and hygienic.
That is, my lord, I am objecting to this, my lord.
Stop. According to the petitioner, the urinal was not in use for a long time. Stop. It has been made to use very recently.
And it is not
And the
clean.
same is not cleaned on regular basis. Stop. Paragraph. As it appears that the urinal has been constructed for public convenience and is in existence for nearly 20 years. Stop. Stop, comma. Accordingly, the corporation is directed to clean the urinal at least twice a day so that the same remains so that the same remains hygienic and free from any foul smell. Stop. Paragraph. The public convenience should not cause any inconvenience to the members of the locality. Stop. The contempt application stands disposed of.
But like a copy of the content application be served on us formally, my lord, to forward to my authority.
Why? It has not been
I have
served.
served, yes. I have filed my affidavit of service.
Affidavit of service is taken on record. Achha. The report filed by the executive engineer, civil / Boro 2, be written with the records. দেখুন তো দুটো কপি দিয়েছে আর এটা কি যা দিয়েছে রেখে দিন ফটোগ্রাফটাও রেখে দিন yes disposed
Matter was mentioned before your lordship on Friday, my lord. All my instructing juniors have left for Kumbh. Can it be fixed, my lord, next week? It has been complied with. There's a problem with the interest, my lord.
Yes, my lord. It was mentioned. I was there, my lord. And your lordship told me to remind me. My lord, kindly let it appear on 5th, my lord.
Please come.
5th February.
By consent of the parties, let the matter appear in the list on 10th of February. 10th.
And for the petitioner, my lord.
Your lordship, I'm for the respondent number 2 and 3. I'm led by
My lord
Mr.
has directed the bank to file a report on affidavit.
I pray for some time to file the affidavit. It is ready, your lordship. I need some time to affirm it.
Two and 3.
Yes, your lordship.
Is the bank taking any steps against you in the meantime? No.
Ultimately, they may take. If a lordship pass a limited stay till they file.
Stay. What is the stay required?
There perhaps is already an order of stay. Not exactly a stay, but there is a.
Any steps taken in the meantime shall abide by the result of the
My lord, page 101. There is a stay order by the Honorable High Court against the Axis Bank. My lord, this is Axis Bank.
Come.
I'm grateful.
Learned advocate representing the respondent numbers 2 and 3 seeks extension of time for filing the report by way of affidavit. Stop. On such prayer, time to file the report by way of affidavit stands extended till 14th of February. Stop. Let the matter appear in the list on 18th of February. By 14th, please serve.
Yes, your
Much
lordship.
obliged, my lord.
In the meantime, my lord, stay order be passed. This is regarding Axis Bank.
Interim order is already there, you say?
No, interim order is this man against Axis Bank, which was the prior bank, which this both bank proceeded on the basis of the same report. Paid 101.
Order records any steps taken during the pendency shall abide.
Subject
So
to-
this is going to cover you.
My lord, I'm grateful.
Much obliged.
Item 6, my lord, I appear for the
I am
private
for the petitioner
respondent.
that Paradise Cinema matter, my lord. The fire license matter is now coming up before your lordship
Your
again.
lordship,
On the
Mrs. Juma Chakrabarti is appearing from state, your lordship. She is appearing
led by
online.
Mr. Basu.
Mrs. Juma Chakrabarti.
Who is appearing?
Mrs. Juma Chakrabarti, your lordship. She is appearing online for state.
State
is supposed to file a
Before my lord takes up the matter, my lord, one humble prayer. I appear for the private respondent number 15. There is a direction upon me to file an affidavit. The affidavit is ready, my lord. It is being affirmed presently. The deponent is, my lord, there affirming it today. If my lord only grants me a day's time, I'll serve a copy upon my learned senior friend and come back tomorrow itself, my lord. It's being affirmed presently, my lord. He was
That's correct,
unwell.
but there is a
He was
direction for the state
unwell. Yes.
to get instruction.
That I
Whether the fire safety license has been issued by the authority in favor of the respondent number 15. Where is the instruction? Yes, State Council.
Instruction আছে এসছে instruction তো দিয়ে দিন
You have a copy? Hand it over. Have you gone through this?
I haven't.
Would my lord take the matter up tomorrow, my lord? Then my affidavit can also come, my lord. That will be only tomorrow. I'm praying.
No problem. Let us have a copy of this instruction.
Yes, let me also, if a copy could be handed over to us as well, my lord.
Please come. A report by the Divisional Fire Officer, South Kolkata Division, West Bengal Fire and Emergency Services, signed on 21st of January 2025. Filed in court today is taken on record. Stop. Let copy of the same be circulated. Stop. Learned advocate representing the respondent number 15 seeks time to file the affidavit. Stop. Paragraph. Let the matter appear in the list on 11th of February. Stop. The report by the respondent number 15, report and affidavit by the respondent number 15 shall be circulated by tomorrow.
Well, we will also directed the circulation of this.
Yes.
Grateful.
And for the petitioner, Your Lordship, in this matter, the passport of the petitioner was blocked. Thereafter, the passport, during the pendency of the writ petition, I was called for hearing. Your Lordship, I have explained to the respondents that the only case against me has been, I've been acquitted in the only case which was pending against me. Your Lordship, I think my learned friend has come with instruction.
I do not know, but did you intimate the authority that you have been acquitted?
Your Lordship, I was called for hearing pending the
Thereafter,
writ
the
petition.
proceeding which was initiated by a show cause has been dropped because
All right.
clearance report has been obtained. Now she can use the passport. Kindly record that.
Is any formal order required to be passed by the passport authority?
No.
Your Lordship, I have not been intimated that that now I can use the passport.
Yes,
So, Your
that has
Lordship-
to be intimated to the petitioner that the petitioner can use the passport.
Or Your Lordship, it may be recorded.
28.
28.
Yes.
Where is the order restraining you from using it?
Your Lordship, there is an Your Lordship would kindly see my prayer at page 13. Your Lordship, Your Lordship would find that there is a file number to in the towards the end. Your Lordship, this file number is given only when when they block the passport. So, Your Lordship, I was intimated that my passport has been
How
blocked.
were you intimated?
By Your Lordship, they had put this file number against my passport, and Your Lordship, from there I came to know that my passport has been blocked.
No formal intimation was given?
Your Lordship, I was told that yes, Your Lordship.
Where,
formal
which
intimation.
page?
Page 19.
Page 19, Your Lordship.
Please come. The passport of the petitioner, which is valid.
Absolutely illegible document.
Valid till?
Your Lordship, till March 2028.
March
15th
2028.
March 2028.
Stood blocked as a criminal proceeding was pending against him or her.
Her, Your Lordship.
Her. Step paragraph.
Acquittal order is at page 22, Your Lordship.
The petitioner has since been acquitted from the said criminal case. Stop. The fact of acquittal has been brought to the knowledge of the passport authority, and it has been submitted by the learned ASGI that the authority on instruction that the blockage has been removed, has been lifted. Stop paragraph. As the petitioner has been acquitted from the criminal case, accordingly, there is no impediment on the part of the petitioner to use her passport. Stuff. The writ petition stands disposed of.
Grateful, Your Lordship.
Hey, 8 to 7 But I appear for the petitioner. my lord.
I am appealing for the respondent back.
But here, what has happened is, my lord, for recovery officer, my lord, I am the owner of the property, my lord. My lord, this particular property was, my lord, mortgaged with IndusInd Bank, my lord. It was subsequently been, my lord, handed over to the asset recovery company, and thereafter getting no encumbrance and, my lord, NOC from the asset recovery company, my lord. I have purchased the property. Now, my lord, I have, my lord, gone through a notification, my lord, for auction of the property by Punjab National Bank, my lord. Seeing this, my lord, I have approached, I have searched, my lord, I have seen that a recovery proceeding is going on. I have made an application for intervention, my lord. Now, my lord, the recovery officer had, my lord, admitted my application. They have sought for documents, my lord, the original title deed, which was, my lord, mortgaged with the IndusInd Bank, as well as the, my lord, Punjab National Bank to produce the mortgaged deed, my lord. Now, my lord, they have called for those documents and, my lord, allowed the auction or the sale to be continue. Now, my lord, if I am not protected by a interim order, my lord, my lord, the intervention application would be infructuous, and I am in possession of the property, my lord.
So you have approached the Debts Recovery Tribunal.
My lord, before the recovery officer, my lord. My lord, a decree.
Did you not file any application before the Debts Recovery Tribunal?
No, my lord, I haven't.
Then that
I
is
haven't.
procedure. What will this court do?
My lord, kindly, my lord, takes up the order once, my lord. Kindly takes up the order once.
And who are the private respondents?
My lord, private respondents are the persons against whom Punjab National Bank is proceeding, my lord. But I am the person affected today, because I have already purchased the property. I am in possession of the property since 2015.
It is a, my lord, it is a sale committed to him.
1 minute. Which document are you showing?
But 211, my lord, is the impugned order, my lord. And may I place, my lord?
Debts Recovery Tribunal. If you are challenged, if you are aggrieved by this order, there is an appellate forum.
My lord, this is today the order, the decree which was been passed, my lord. When one of the party who was the original owner of the property, my lord, he passed away. My lord, decree was, my lord, decree was passed today, my lord. The recovery officer is acting on the basis of the decree. Decree, my lord, today the decree is a nullity, because was passed against the deceased person, my lord. Face of it, my lord, it is a nullity. Now, my lord, there are null order, my lord, they are trying to enforce, my lord, in this recovery proceeding. My lord, kindly seize, my lord, the order, my lord. In the above, IA, the intervener prayed for recalling and or setting aside of the sale notice dated 22nd November 2020.
But this order, if you are aggrieved, there is a separate forum. How is the writ petition maintainable? This I cannot understand. Yes, please.
Difficult question, my lord. I asked myself and him the same question, because this is an appealable order.
Yes.
There's an appealable order under section 30.
Right.
And then, my lord, I just looked up a little bit, and my lord, I would like to develop only with this aspect, with the undertaking that I'll go before the Debt Recovery Appellate Tribunal. In the interregnum, your lordship will grant some protection, because your lordship has seen the recovery officer, or the, in respect of a certificate proceeding, the entire proceeding happens according to the second schedule of the Income Tax Act. Under the second schedule of the Income Tax Act, under Rule 11, Sub-Rule 4 and 5, a person can go and make an application in the nature of Order 21, Rule 9801, where I can say that you're trying to sell a property in which I have some interest. He is duty bound under the law to examine what right I have and whether I have the right in respect of the property. If there's a title, then whether the property can be sold. He embarks on this. He calls for a report, but he also directs that the sale will continue. So if the sale happens, then there's nothing left. So
I can understand, but then does this bench have determined the writ court, rather the writ court, whether the writ court can interfere in this matter?
Yes, similar issue had arisen before the Supreme Court, where on a 226 application, an award passed on by the MSME under the MSME Act was assailed. So the argument there was that the MSME Act, because Arbitration Act is applicable, you have to go and challenge the award under Section 34. Supreme Court holds that when the statute requires you to do certain thing in a certain way, and you've not exercised your jurisdiction and you've passed an order, then a 226 will lie, because a party can't be compelled to take recourse to a provision of an act which you've yourself acted the horse of. But I understand, my lord, and I don't need to trouble the court to this extent. I will be only praying for this, that your lordship would have found from the impugned order here, if I may just show that he's deciding the aspect whether I have a right, page 211 second volume, if your lordship has a look at.
Page 213, I can see the case was adjourned till 17th of January 2025 for sale by e-auction. That date is over.
No, that has not happened. So what is the case adjourned to 17th of January for sale by e-auction?
Did the e-auction take place?
No, that I don't know. The
Yes.
order is of 15th of January 2025. But if your lordship looks at page 212, kindly have a look at 3 paragraphs, my lord. The third paragraph at 212.
1 minute, did the sale take place? Did the e-auction take place or not?
That they will be able to say.
The bid was risen up to 78 lakhs. It has been sold.
It has been sold.
Sold. Now, my lord, I have only one submission left. Petitioner has approached the recovery officer. The recovery officer, rightly or wrongly, has passed an order. I assume that. Now, in tandem, he invites the High Court to act on that. So, two authorities, my lord, cannot act together. This is a read jurisdiction. There is a simple order of
You are for the bank.
I am for the bank. For responding.
Tell me whether the auction took place or not.
Yes.
No, whether a sales certificate has been issued.
Sale certificate has been issued.
No, my lord,
What
can't
is
be.
the due? What is the due?
What is the due?
I am not a borrower.
And due from whom?
What is the due?
68 lakh.
68 lakh.
68. And the petitioner is not the borrower.
No.
No, the petitioner
Right.
is not.
I am the purchaser of the property.
How did the petitioner purchase the property? Not from you?
No. So that is the thing. My lord, when we make a search, there was only one loan with regard to this particular property from IndusInd Bank. IndusInd Bank also has given a no due certificate. So we go ahead and purchase the property. Now we find this application that has been taken out. And if your lordship looks at 212, your lordship will find that the recovery officer also has directed material particulars to be placed before him and for a report to be filed. While he is still exercising this jurisdiction, he doesn't stay. So what is the point of him examining my right if the property is sold to somebody else? This is my property. I have a registered indenture in my favor. A recovery officer, the recovery officer today cannot hold that this particular indenture is bad. This is outside his scope. He has to examine whether the property was mortgaged, whether I could have.
If you sell off the property, you sell off it in as is where is basis. So he is already there. You're not throwing him out, isn't it?
Not, I will test all this.
Yes, I understand.
Physical possession has been taken over by the bank. Right?
No, I'm in possession.
Now,
That's my
Lord,
specific prayer, pleading.
My lord, he is actually going deep. If it goes deep, my lord, then my lord, it becomes serious.
Let the
There is a
recovery
fraud
officer
sale.
decide all these issues.
There is a fraud sale by wife and
A
guarantor.
fraud sale, the recovery officer is not the competent authority to decide.
No, he has approached the recovery. Your lordship kindly appreciate.
Yes, but in the meantime, if the property gets sold, then what will happen
Has
to his right?
approached the recovery officer.
Right.
The recovery officer is asking to respond. Then he is coming to this jurisdiction. Your lordship will decide
So,
whether it is
in
fit
the
for
meantime, if the property is sold, then what is his right?
the deed was with us mortgaged from 2005, and there is something inside which I don't want to pronounce. There may
Show
be
me
a
the
case of
judgment that
color
you are
xerox.
relying upon.
Yes.
Article 226.
Yes.
Why not in a revision? Why not in appeal? You come up in Article 226.
I'll tell you, lordship, why.
Then
This argument that he advances that I am parallelly pursuing two remedies, that is not what I am doing. I have invoked the statutory authority. He has not exercised his jurisdiction. Kindly have a look at
the appeal. He will not, my lord, he will not choose the appeal.
this is 2021 19 Supreme Court cases 206. Jharkhand Urja Nigam.
Which paragraph are you
Yes,
relying
ma'am.
upon?
Your lordship will just have a look at My lord, the third paragraph once. Third paragraph. The said order was challenged before the High Court by way of a writ petition in so and so, and the same was dismissed by the learned single judge. An intra-court appeal preferred by the appellant was also entered in dismissal. Hence this appeal. 34 point was taken. And if your lordship finds, just give 5 of cursory glance, my lord. Your lordship will find this is an award that was there. 6 is also that. Now, if your lordship turns over, paragraph 10. Just the first line. In this writ petition, the appellant has challenged the award dated 6th August 2012 passed by the second respondent council constituted under the provisions of MSMED Act. Then all this is taken out. Kindly have a look at paragraph 18. The order dated paragraph 18. The order dated 6th August 2012 is a nullity and runs contrary not only to the provisions of the MSMED Act, but contrary to various mandatory provisions of the Arbitration and Conciliation Act 1996. The order dated so and so is patently illegal. There is no arbitral award in the eye of law. It is true under the scheme of the 1996 Act, an arbitral award can be questioned by way of an application under 34 of the Arbitration and Conciliation 96. At the same time, when an order is passed without recourse to arbitration, in utter disregard to the provisions of the Arbitration and Conciliation Act, Section 34 will not apply. We cannot reject this appeal only on the ground that the appellant has not availed the remedy under Section 34. So if an order is without jurisdiction, now similarly, if your lordship looks at the second schedule of the Income Tax Act, kindly have a look at Rule 11 and what is the extent of investigation by a tax recovery officer, in this case, the recovery officer himself. I had a copy now. Lordship will forgive me, I had just one copy.
Yes.
Kindly have a look at Rule 11. This is absolutely settled that this recovery happens in terms of the second schedule to the Income Tax Act that the statute provides. Kindly have a look at Rule 11, Rule 4 and Rule 5. A person is entitled to go before the recovery officer, and the recovery officer is to examine whether I have a right of possession and what is my claim in respect of the property.
But why is this showing the? Why are you showing the provisions of the Income Tax Act? This must be done under the surfacing proceeding.
No, Mullah, this is OA. This is original application under 1993 Act. The 1993 Act makes recovery proceedings in the same manner as in second schedule to the Income Tax Act, which is how an intervention application lies before the recovery officer. If your lordship looks at the provision, I'll just show it. DRT Act. The recovery proceeding under the 93 Act happens in tandem with the second schedule to the Income Tax Act. And if your lordship has seen, he's exercising the jurisdiction under Rule 11 to examine what is the scope of a sale of a mortgage property, if at all mortgage, and what is the right of a person who claims that the property has been sold or bought by him. There is a registered indenture. Well, not insofar as he directs a report to be filed, and for me to do all of this, he's all right. But where he does not stay the sale, it is patently illegal, because if the property is sold, then what investigation will he do under Rule 11?
There is a registered indenture.
All that is not for the bank to say. Bank may think the recovery officer is its fiefdom. Not here. This is not a recovery tribunal. This is a 226 court. I'm saying that the jurisdiction has not been exercised in accordance with law. It's a patently jurisdictional error, where the Rule 11 of the Act of the second schedule mandates you to look into certain aspects. You have exercised the jurisdiction, but you've allowed the sale to happen. Then if he holds in my favor, what is he going to do? This will be absolutely set at naught. My only limited protection I want, if the sale has happened, till he decides it, let the sale certificate not be issued and makes it time bound. The recovery officer will examine this within 2 weeks from today. I have absolutely no qualms with that.
The deed is with us from 2005. Now there is a registered indenture of the same deed.
And Milord,
This is the case, my lord.
the next date is fixed on 30th of January 2025 before the recovery officer. Kindly directs him to decide it on that date itself. Till then, let them. Today we are on the 26th, 27th.
Where from did you get the date of 30th of January?
My junior just find it out, Milord, and it's on the website.
Please come.
It's on the website. It is there on 30th of January. Please direct him to decide it on that day or within a week from that day, whatever your lordship deems fit. Let the sale certificate not be issued in the meantime, Lord, till this decision is taken.
Why not then kindly observe that deed is with the bank, with me, since 2005, and the submission is that there is a registered indenture on the same
What
deed
is there
by
to
a separate
observe?
bank.
It is on record. You say if it is with you, it is with you. My recording is not going to improve
It is now with the
anything.
DRT. It's a fraud.
Whatever.
It's a fraud sale by
Very
wife,
well.
by
Let the
wife
authority
guarantor.
decide and take a decision.
That's
but
all.
then at least let him be heard. Without hearing him, you are throwing him out.
No. The recovery
the
officer
petitioner
is acting within his jurisdiction.
Is aggrieved
He has
by the
approached the recovery officer.
manner in which the recovery officer, DRT 3 Kolkata, has proceeded in case number RP/124/2021. Within bracket, Punjab National Bank versus Srimati Anuradha Giri and another. But did you serve the private respondents?
Yes, we've served.
Where is the affidavit of service?
Key to me, file.
They can just serve it again.
But I haven't seen it. I'm told it's been served and the affidavit of service has been filed.
Actually.
And private respondents are predecessors in title. I haven't checked it. Not I. आपने देखे जनता? ठीक है. ठीक है. Item delivered, ना?
The petitioner claims to have purchased the subject property, which is allegedly mortgaged to the. You are the Punjab National Bank.
National Bank.
Punjab National Bank. Stop next. The Punjab National Bank, by way of an indenture of sale.
Decree to against a dead person.
Registered indenture of sale. The as there were certain amount due under the due in respect of the Income Tax Act, 1961, the recovery officer proceeded with the sale. Stop paragraph. The petitioner is aggrieved by the same and submits that as the matter is pending consideration before the recovery officer and date has been fixed on the 30th of January 2025, the application of the petitioner for intervention will become infructuous if the sale takes place in the meantime. Stop paragraph. From the impugned order placed before this court, it appears that the date for sale by e-auction was fixed on 17th of January 2025. Stop. Learned counsel representing the bank submits upon instruction that the sale took place on the said date. Paragraph. The sale certificate is, has, however, not been issued till date. Has, however, not been issued till date. Paragraph.
Income tax recovered.
On the ground that the writ petition will be maintainable before this court. At this stage, the petitioner relies upon the judgment passed by the Honorable Supreme Court in the matter of Jharkhand Urja Vikash Nigam Limited versus State of Rajasthan and others, reported in 2021, 19 SCC 206. When the court wherein the court observed that, not observed but held, that when an order is passed without recourse to the proper provision of law, comma, the remedy under Article 226 is available. Stop paragraph. The petitioner submits that if the sale certificate is issued despite the petitioner purchasing the subject property by way of a valid indenture of sale, comma, then the petitioner will be left remediless. Stop paragraph. Learned counsel representing the bank submits that the original title deed of the subject property, subject mortgage property, is in the custody of the bank. Stop.
Now under DRT.
Acha, in possession of the Debts Recovery Tribunal. Stop. It has been contended that the petitioner is not in possession of the mortgage property. Stop. The sale is an absolute fraudulent one. Stop paragraph. It appears from the submissions made on behalf of both the parties and on perusal of the materials on record that the recovery officer is already in scene of the matter and is examining the right of the petitioner to hold the subject property. Stop paragraph. If in the meantime the property is sold and sale certificate is issued, comma, then the petitioner may remain non-suited. Stop paragraph. Next, in view of the above, only for granting an interim protection to the petitioner to agitate all points before the recovery officer, comma, the instant writ petition is allowed. Stop. The recovery officer is directed to decide the right of the parties, including the petitioner, and thereafter pass necessary order for issuance of sale certificate if the sale did actually take place in accordance with law. Stop paragraph. The recovery officer shall take steps in the matter at the earliest. Stop. The bank is restrained from issuing the sale certificate till 28th of February 2025 or until further order passed by the recovery officer, whichever is earlier disposed.
And I have one indulgence to pray for, my lord. Lordship will direct the recovery officer to complete this by the 28th. That much your lordship will just.
I have directed to decide it at the
I know, my lord,
earliest.
but I know, but sometimes just one line I'll be able to put. Otherwise, the interim order will be there till 28th. He'll take it till March. I'll have to come back and trouble your lordship again.
It is expected that the recovery officer shall decide the issue within the validity period of the interim order.
Very grateful.
And if the issue cannot be decided within the aforesaid time limit, comma, then the recovery officer shall take shall decide whether to extend the interim order or not.
I'm very, very grateful.
Obliged.
হ্যাঁ
May I be permitted mention Peter origin?
Yes.
Epilepsy. Lordship, may I be permitted on Lordship indulgence?
No.
On metal. Lordship,
No. Mentioning
Freedom
is
fighter
wrong
pension,
over.
Lordship. Freedom fighter penda, your Lordship list is 1770.
The mention, this is not the mentioning time. Yes.
Item 2, I am for the petitioner. Here, petitioner before your lordship, I am giving the facts. Thereafter, I am paying, submitting the documents. Petitioner before your lordship is the assistant teacher of a madrasa. He has a bank account, salary account with the Barasat SBI Bank. All on a sudden, on
What
20,
was the bank?
yes,
SBI?
yes, all on a sudden on 21st of October 2024. At about 8:30 onwards, he got some messages that from his bank account, that bank account, 7,28,000 has been generated, creating a loan account, showing that bank salary account itself, without any knowledge of the petitioner. But thereafter, 7,28,000 has been siphoned by 5 installments. 4,99,000, all these statements are there. 99,000, 99,000.
Petitioner is no way connected with
No
this
way
loan.
connected. Immediately thereafter, on very that date, he rushed to the bank first. Bank manager said, you file a complaint before the police authorities. Immediately, he went to the police authorities, as well as the cyber report. Rushed with all these reports. But complaint lodged before the bank authorities on very that date itself. But they did not take any step. Ultimately, FIR law 6/11/2024. And details I have collected that petitioner is nowhere connected generation from somewhere else with the somewhere phones. Now when I am placing the facts itself, paragraph 9, I have stated.
What is your prayer?
My prayer not to deduct. But now after 23rd of October, each and every month, total loan amount has been to be repay 10,55,000, and I am liable to make EMI 14,397 or something at each and every month deducting. First thing,
Automatically deducted.
automatic deduction without any fault on my part. Till date, 2 installment already gone, and I have to pay till 30th 2030. 223 installments I have to pay without any fault on my part. Now, immediately thereafter, after that generation, time and again, SDO, DI to stop EMI salary, so that, and most interesting thing, till 23rd of October of every month, salary is giving in that particular month, 1st of every month. Till 23rd of that month, I cannot operate even my bank account unless until the deduction made. But kindly see the plight of the petition.
Right.
I'm giving the documents itself.
Let me hear the bank.
Yes, yes.
My lord, this is a very sorry state of
And a
affairs.
Supreme Court judgment
But it
latest
would not have happened
on 3/1/2025 that if there is no fault on our part, Honorable Supreme Court following the earlier judgments, I have got all these judgments, series of judgments, that if there is no fault on part of the petitioner or the customer, then it is the bank to provide all the highest level of securities to. But this is the judgment. First judgment from Assam, single bench, carried to the appellate court. Appeal bench confirmed that. Supreme Court, bank, all these judgments I have given till 2019, and those judgments has been followed on 3rd of January 2020, which is the latest one. Quoting the paragraph 42 earlier judgment,
Yes.
earlier judgment, page 3.
Petitioner is only 38 years of age.
Yes, well, my client is before your lordship. I have bought him. If any requirement or query is there,
No, whatever. Yes,
Prima facie, it appears to be a very sorry state of affair. But it would not have happened unless and until he has shared the OTPs that he has received
now
on his.
something has happened.
My lord, we have conducted an internal investigation.
Yes.
My lord. My lord, this is an internal investigation report that I'm placing before my lord. My lord, can you see?
With a copy to your learned friend.
My lord, if my lord directs, I will allow.
Yes, yes.
My lord, I'm having what it.
What does the report say?
My lord, we have conducted an internal investigation which says that
You give a copy to him. He can also see what is there.
Due to his negligence or carelessness, he has shared the OTP numbers. There was a fraudulent transaction. It happened. But unless he had shared it, the numbers, OTPs, this would not have happened. He has received a loan. This, my lord knows, this is a INB platform, internal banking platform. And every internal banking platform, whether it is or Paytm or Google Pay, every internal banking platform has a loan facility. We can obtain personal loan from that internal banking platform. Now, only after pressing that application, the loan will automatically not come in my account. After pressing the application,
something has happened.
I
now
receive
what,
various OTPs.
What can be done? What is the remedy, you say? The remedy, you have to find out a remedy. What is the remedy? What does your internal investigation report say?
My lord, kindly cease, my lord.
It may have maybe that he has committed a mistake, a negligence, whatever.
My lord.
What is the remedy?
My lord, now the loan has been obtained by him.
He is not getting the money.
No, maybe, but
maybe?
We cannot
His
deny
money will
this.
go somewhere else.
Kindly appreciate, my lord. We cannot say that he has not done this because OTPs were shared by him.
Immediately block this account.
Knowingly or unknowingly, we do not know that.
Immediately block this account. Block it, so that no further money can be deducted.
No, we are deducting the EMIs because
Do
he has
not
obtained
do
the
it
loan.
because the
He has
loan.
obtained the loan.
He is not using the loan. Some fraudster is using it.
That is his allegation, my lord. That has not yet been proved, my lord.
You find out.
That is not his allegation only.
Of the state respondent. This is
If
the
my
report
phone
from
is
the
hacked.
cybercrime police station.
Yes.
And it suggests that the investigation is still going on and petitioner is nowhere connected with the loan.
The investigation going on and not still
Phone has been
connected.
hacked.
Both
and
are
even
contradictory,
my
my
phone number it has been. OTP question does not arise.
You immediately block this bank account so that no transaction in any manner whatsoever takes place from here. Right? Thereafter, EMIs and everything can be taken care of. And you give a copy, your investigation, share it with the learned advocate for the bank as well as the petitioner.
এই কোথা থেকে কিছু হয়েছে কিছু বলেছে from where?
IP address suggests that it's happened out of West Bengal, somewhere out of West Bengal.
Then
have you followed?
No, it may
Your
happen.
maybe will not do.
But he has received OTP in his mobile number. That cannot be received.
He has been hacked
Done it
thereafter.
by way of a mistake. Even if assuming it is a mistake, you have to stop it. You cannot permit money to be deducted and credited in favor of somebody else. You are a bank. You are providing service to your customers. There is a fraud. There's an allegation of fraud and you'll say that you've taken the money. He lodged a police complaint. The police is investigating. Immediately take steps to block it so that
he has got an alternative remedy, I say, my lord.
Yes, please.
We have already rejected his claim, the ombudsman. Now he can file another complaint before the Reserve Bank.
Permit anything to be done. You immediately stop it. And he will be permitted to open a separate salary account where his salary will be credited. And you, in the meantime, inquire to get hold of the money that has already been siphoned off. Do you get it? The way you are moving, as if these things doesn't happen, he is the only person who is doing something like this. Right?
And
so do not
any person. I just academic question. I
No,
put
no,
it
no,
to
this is
myself,
not
my
a
lord.
place of academics.
If somebody does it intentionally, we will not be able to
How
judge
that
who has done it
incident
intentionally or
after
not
hacking, I
intentionally.
don't know what is happening
Then
there.
like this
After
money will
The
go
bank
off.
authorities
Public
are
money.
responsible.
Public money will go off, my lord.
After there is a complaint that this has not been done, then you find out where the money has gone, in whose account it has gone. You find out who is the beneficiary of the loan.
Much obliged.
Then only the customers can be protected. Otherwise, the customers' money will go in this way. I am getting regular matters where bank accounts are frozen only because of these fraudulent transactions. Can you not find out where the money is being credited? Every month you are deducting some amount of money. Where the money is going? In whose account?
No, that is the EMI we are deducting, not
the
to,
main,
it is not going to somebody else's account.
The main money was taken by somebody. Where did the money flow? Find out.
And Honorable Supreme Court said this within 24 hours. If I make any application, it is the bank's priority to investigate and stop all these things.
My lord, we have already
Paragraph
done so.
9, 10, 11.
My lord, we have done so already. My lord.
Paragraph
Since
9, 10,
the
11 statement is
Correct.
there.
My lord, we have already done so. Bank has submitted copy of EML dated such and such address to PNB Bank, beneficiary merchant.
Find out who is the
Beneficiary merchant
beneficiary.
for recovery of dispute or transaction.
Yes. Take steps for recovery. That is your prerogative.
Yes.
You are there to safeguard the customers and not harass them by dismissing their complaint by the ombudsman and telling them to file a further complaint. This is not done. And tell your client to be careful next time.
He did not. What happened? I asked time and again. His phone was hacked by that time. Immediately thereafter, all this transaction done. If my number is hacked, there is no operation is there. But he is here. I totally I asked him.
The petitioner.
Mr. Saravajaman's mother, 70,000 within operating everything.
Is a teacher of a high madrasa.
Paragraph 9, 10, 11 statements.
His salary account was hacked and a loan was generated from the said account.
Is 37.
And
38 the mode of generations.
A sum of rupees 7,28,000 was immediately deducted from his salary account.
No, my lord. It is loan account has been credited.
Loan account has been
without any consent of the school authorities also. It cannot be permitted.
A loan account
Separate.
was created.
Yes, I have given the number also. Paragraph 10.
How much has been deducted as of now?
7,28,000 generated in terms of the creating a loan account. That entire amount has been credited to that account. Debited from that
Salary account,
yes,
and credited to somebody else's account.
Creating a loan account, another from that loan account it has been sent to another account, and now they are generating my EMI from and debiting from my salary account each and
that I understand. But then the amount was debited from your account and credited to somebody else's account. Find out.
Yes. And that statements are there. Page 39 onwards. 38 mode of generation. Page 37 is the how it has been created from time to time. And thereafter time has been given. Kindly see. Page 38. iPhone. I do not use any iPhone itself. Mode, makeup, mobile platform, iPhone such and such. All these things are there. I do not have any iPhone. From that iPhone, creating of my phone number, hacking, transferred.
And a loan was a loan account was generated বললাম and যেখানে লিখেছেন তারপর লিখুন and the loan account was generated.
Paragraph 9 loan account also given. PALCC such and such. My lord, it gave
The,
all these things from paragraph 9, 10, 11.
the bank is deducting the EMI from the salary account of the petitioner
Grateful.
every month. Stop paragraph. The petitioner immediately lodged a complaint before the bank and thereafter before the
Police, cyber, all.
Stop. An FIR was also registered. Stop. The petitioner asserts that he is no way connected with the loan. Stop. He never applied for loan. Stop. The petitioner requested the bank to freeze the bank account and to create, not create, and to open a separate salary account where his regular salary may be credited. Stop. The prayer of the petitioner was rejected by the bank. Stop. The petitioner is aggrieved by the same. Stop. Prayer has been made to restrain the bank from deducting EMI from his salary account and also permit the petitioner to open a new salary account. Stop. Learned advocate representing the bank submits upon instruction that the petitioner is responsible for creation of this loan account. Stop. According to the bank, the petitioner must have shared the OTP number which was provided to him. Otherwise, the loan account could not have been generated. Stop. As the loan account is continuing, the bank has to deduct the EMI. Stop. Paragraph. The petitioner has annexed the bank statements, wherefrom it appears that the loan account was generated by way of an iPhone. Stop. Paragraph. The petitioner submits that he does not have or own any iPhone and he never disclosed any OTP to anybody.
Kindly come to page 51. It is a bank statement that fraudulent transaction has been made. It is their statement. I have got it. Subsequently on 30th10. Page 51.
Paragraph. The bank has conducted an internal investigation. And has opined that there was negligence on the part of the customer. Stop. Paragraph. The learned advocate representing the state respondents has filed report before this court.
The staple one was the present report.
Yes. And this is the earlier one.
Earlier one.
Where is it mentioned?
Annexure B1. Annexure B1 in the that folded page.
Folded page.
Annexure B1. It's IP address. Login IP address. Suggests that somewhere in Bihar it has been used. The user ID and password used somewhere in Bihar.
Where is it mentioned? In your report that it took place in Bihar?
It's annexed in annexure B1 and B2.
B1 and B2.
B2 that is yes.
A1. Where is it mentioned, Bihar?
It's we are roaming. It's the IP. The phone is in
अच्छा roaming. ठीक है, तो
and
लिखो तो.
roaming in Bihar.
State has filed with dispute.
File report filed by the inspector in charge. Cybercrime PS, Barashat Police Division, signed on 27th January 2025. Annexing documents which suggests that the transaction took place somewhere in Bihar. The police opines that the petitioner may not be responsible with the fraudulent transaction. Stop. The investigation is still under progress. Stop. It appears from the submissions made on behalf of the parties that the petitioner has been a victim of fraud, has become a victim of fraudulent online transaction. Fraudulent online banking transaction. And he has been cheated. Stop. His salary account is the his salary account has become the subject of the fraud. Stop. Certain sum of money stood deducted from the bank account of the petitioner without his knowledge and consent. Stop. The police is investigating the crime. Stop. The bank is also directed to continue with the internal investigation and try to find out the beneficiary of the said fraudulent transaction. Stop. Paragraph. The respondent authorities shall take steps to recover the amount which the petitioner has lost in the meantime. Stop. That's a paragraph. As the petitioner is a monthly salaried person, comma, the bank shall permit the petitioner to open a separate bank account where his salary may be deposited. Stop. The existing bank account of the petitioner shall immediately be frozen so that further money cannot be deducted therefrom for meeting the EMI. Stop. Paragraph. What are the further steps that can be taken?
DI, I have made him party. Only no objection for creating the salary account. DI's permission is required by the school authorities. School authorities will approach the DI. DI will take appropriate steps.
Leave is granted to the petitioner to approach the district inspector of schools.
He is party there.
For obtaining permission for opening separate salary account.
Yes.
In the bank.
And the school will cooperate.
Stop.
The
madrasa. School.
Is madrasa. This is madrasa.
Achha, the madrasa is directed to cooperate with the petitioner and the bank for opening such bank account. Stop. Next. The respondent authorities shall intimate the petitioner, shall regularly intimate the petitioner the fate of the investigation so that the petitioner can take further steps in relation thereto. Stop. The writ petition stands disposed.
Let it be, keep pending up. Let them file a further report or something else because it is I am apprehending too.
For obtaining further updates in the matter,
yes,
let the writ petition appear in the list on 4th of March.
Grateful.
My lord has held, since my lord was dictating, so I did not say anything. My lord, upon hearing the submissions of all the parties, it is found that the petitioner is victim. We have submitted the petition as a victim of fraud. My lord, that I have not submitted.
No, you have not submitted. Your report says otherwise.
Yes.
Your report says he is responsible.
Yes. No, my lord has.
I'll take care. The police finds out
that it has been submitted by the parties. The petition is a victim of
police
fraud.
found out that the transaction took place in Bihar.
That is
from a iPhone.
It is mentioned in their report itself.
Dictated that.
Serve a copy upon him so that the bank also gets to know of what the investigation is.
Grateful.
Kindly.
I will take care.
Kindly keep the judgment of the Honorable Supreme Court.
All right. Thank you so much.
I am obliged to your lordship. Immediately after filing this, Lord, I have got that latest judgment.
Lordship, in this matter, I am for the responding, appearing for the respondent. In deference to your direction, your lordship, I have served the papers, including the evidence that the tenderee is already carrying out the contract.
Lordship may recall, may come back to your Lordship, my lord, on the previous week. My lord was pleased to take up this matter. This is at the instance of the L4 tenderer in connection with supply of sulfuric acid, where L1, L2, and L3, all parties in the writ petition and served, do not qualify even for the technical bid, let alone the financial bid. There was a gap of only 5 minutes between the e-technical bid and the e-financial bid.
1 minute. Are the private respondents present today? Nobody.
They've been served. I've seen, my item has been delivered to each one of them.
All right.
Now, my lord, from the documents that have been handed up to your lordship, my lord, it's a shocking state of affairs. And after on the face of it, I can show that.
The authorization of the L1 bidder was supposed to be handed over to you. You got it?
Authorization of the L1 bidder was supposed to be handed over to me on that day when my lord was pleased to pass the order. It was handed over on Friday.
Whatever. Now
late afternoon, I have got it. What emerges from this is shocking.
All right.
Shocking. Please see.
Yes.
Please, my lord, takes the compilation that I had given to your lordship, lord, on the earlier occasion in order to make your lordship's navigation through this brief easier. Act as a spiral bound.
Yes, yes.
Before that, my lord, please come once to page 122 of the writ. This is not there in the compilation. Volume 1, 122.
Yes.
And while at it, my lord will also please take page 64, 122 and compilation. These are all the papers that may be necessary at this stage.
122, 64.
Please come to 64, then 122. Then I'll take your lordship into the compilation. It's shocking what has happened.
Yes, and the compilation.
Yes. Now, my lord, can you come to 64?
Yes.
My lord has seen title of the NIT's procurement of sulfuric acid. Please straight away come down to technical bid opening date. This is
Yes.
somewhere down the middle of the page.
24th of June, 15 hours.
2024 at 3 p.m., 1500 hours. Uploading of technical bid evaluation sheet not
Be
provided
notified.
to be notified through system generated message.
Yes.
Financial bid opening date to be notified through system generated message. So at some part in the future, after that technical bid opening. Uploading of financial bid evaluation sheet to be notified through system generated message. Estimated cost is 2,45,94,100. So it's a fixed cost which is estimated. Now, please come to Milord page 123. 122, I'm sorry.
Yes.
This to be notified later, that mystery is broken down. Please come to the last rectangle at the bottom of the page. Please be satisfied when I submit. Updated on 18th November 2024. That's the technical evaluation bid summary details. Financial bid opening date is now mentioned immediately 5 minutes after the date. Why is this gap of 5 minutes? So that if any of the participants are aggrieved by the awarding of technical bids, he doesn't have a knee-jerk reaction to even send an email before the financial bid. What is the irregularity? And I'm saying so with responsibility. L2, L3, those who have been given, ex facie do not qualify because they don't have the eligibility criteria. L1, ex facie does not qualify because he doesn't have the eligibility criteria. What's the criterion? Sulfuric acid is being sent. I am the unsuccessful bidder, L5. I am the only manufacturer who directly supplies. All other participants are procurers from manufacturers. So L2 and L3 have badly been unable to show that they meet the norms. They do not give any of the certificates, but they have not been given the tender. Tender goes to L1. L1 on the date was supposed to give in his technical bid and not financial, in his technical bid, authorization from a company which is a manufacturer that during the contract period, they would be supplying the materials to L1 along with pollution and explosive license. This is a precondition and this is a mandatory condition. Please come, Milord, to page 70 just once. 6 more pages after page 60.
Yes.
Milord, the technical, as far as the technical criteria are concerned, page 69, please come to Roman 6, Roman 2, Roman 3, and Roman 6.
Yes.
Must be manufacturers or authorized vendors, Roman 2. 3, manufacturers or authorized vendors or manufacturers only to give information asked for as a single entity, so no consortium business allowed. 6, vitally important, bidder must, kindly see the language, bidder must have credential or experience of executing similar nature of supply, means delivery of sulfuric acid under quasi-judicial so-and-so. And after that, Roman 7, bidder must be having valid explosives license and clearance from PCB. Clearance means consent to operate and consent to establish. And all allied documents required for execution for the supply of acid in transit. Related documents must be submitted along with the bid for verification and would also form, and here, Milord, I lay stress, an essential part for technical qualification. These are not given. What is given in terms of the OEM, the manufacturer's authorization, is a letter. Kindly seize that letter. Please come to the compilation. It's a part of the writ.
So you say that the L1 doesn't have a valid explosive license.
He doesn't have a valid explosive.
1 minute.
L1 doesn't have a valid explosive license. L1 doesn't have clearances from PCB. L1 doesn't have a valid authorization of supply of materials at fixed price. Please come to 119. Please come to internal page 9 of the compilation now. It will help your lordship. Please go through those clauses again. Please be satisfied when I submit that these are the criteria. They have been earmarked to be mandatory.
If the bidder has to provide all these documents, then what is the use of the authorization?
If the bidder has to provide I'll tell you, Lordship, what? This is the term of the tender. Why is it the term of the tender? Authorizations are sometimes ad hoc, they are sometimes fishy. And I'll show you, Lordship, how fishy this authorization was. This is a fixed price tender, my lord. Total X crores and odd. X amount of supply of sulfuric acid has to be made. The measurement is in tons. So rupees per ton is a fixed rate on which the financial bids will go. Financial is part 2. If your manufacturer does not guarantee supply at a particular rate, you cannot give that as at a particular rate. If manufacturer says,
Yes,
I
yes,
can
I've
increase
followed
the
that.
price. So to do the double whammy, at this stage, the manufacturer's authorization is required that for this contract, for this period, I will continue to supply you goods so that you meet the rate. This is not given. Quality and rate are both required to be confirmed. It's not given. What is given is this. Milord, kindly sees, Milord, page 9. Please bear with me.
Page 9
Of the compilation. That's at 119 of the writ.
Yes.
This is Khaitan Chemicals and Fertilizers Limited, which is the alleged manufacturer, which is allegedly confirming. Mr. Solanki, Vice President, is writing to the PDCL on 24th of June 2024.
This is the authorization.
Authorization. This is uploaded. This is uploaded.
All right.
Please see, my lord. However, this authority is valued up to 31/10/2024. My lord has seen. And the work of tender starts after November. Your lordship has seen that sheet, supply sheet.
The putting the date of bidding, putting in the documents, the uploading 24th of June.
Just a second.
Technical bid opening, filing date is sometimes in June 24. So it was valid till October.
It was valid till October. So he's supposed to cover it for that 1 year period.
Yes.
That is the rate. So this is valid till October. This is what he has put in. This is part of the
documents
uploaded. All of that is available in the public domain, all printed and taken by me. So now, after doing this, if he goes in, the moment he does this, he is not covering the entire tender period. Please be satisfied when I submit. Tender is for a particular supply for a particular time.
Yes, I followed that.
Doesn't follow?
Yes.
Now, the moment he doesn't do that, it's an essential term of the tender. Clause 7 says he should not even qualify, but he is made to qualify. And subsequently, allegedly, he gets an authorization. Your lordship will be shocked. Please see, my lord, now. Now, kindly see the bunch. The subsequent thing can't happen in tender law.
Show me, please.
Please come. Please come to the last. My lord, a bunch has been handed up to your lordship.
Yes.
Please come to the last bunch, last of the bunch.
Yes. 24th of June, 2024.
What has seen? Please see the last line has gone.
Yes.
What does this mean?
All right.
That is gone.
Exactly same letter, brother. 1 second. Exactly same letter.
Same.
Last line is no longer there. So someone made it retrospectively in 24th of June. This was not uploaded along with his bid. This is number 1. Number 2, the cat comes out of the bag. Please see, my lord. Then when the question is asked, Mr. Shiladitya Chakraborty, the gentleman of AWB PDCL who's handling the affairs, after the tender process asked this particular manufacturer, please confirm whether you've sent. Manufacturer straight away says, I can confirm supply, but I am not sure about pricing. For that, I am not responsible. Please see. Please come to the mail at December 23. So, my lord, when was the financial bid opened? Financial bid was opened on 24th of June 2024.
Technical.
Sorry, 24th of June 2024 is the opening date.
18th November financial bid.
Oh, sorry, I'm sorry, 18 November. 18 November is the opening date. Now, kindly see. On December 23.
Then we are not responsible. Yes.
Please see, my lord, the next. We have received an authorization from your end.
Which page?
That's that internal page. They have not marked it. My lord has seen the mail. Two mails are there.
Yes.
One is top right is December 23, 2024 at 2:59.
Yes.
So that's the subsequent mail. The earlier mail is December 2024 at 10:50 a.m. My lord has seen bottom in that page itself.
Yes.
10:50. Now please see. Dear sir, who's writing to whom? Secretary of KCFL, that is Khaitan, whatever, that's the manufacturer, is writing to Anup Jana of WBPDCL. Dear sir, no, Anup Jana is writing to the secretary, I'm sorry. Dear sir, we have received an authorization from your end as attached here. That attached here does not have that line. And as submitted by your dealer, Messrs. Sudha Chemicals, that's L1, on which we are planning to place contract for 1 year with a provision for extension for another 6 months for the supply of sulfuric acid for our 3 plants of WBPDCL. In this regard, you are being requested to confirm your OEM authorization till the contract period, including extension if the case may be, on the issue of supporting from your end. Earliest reply from your end is solicited. December 24. Please see, 1 month later, Shiladitya is writing personally. Answer comes from them, and the answer is a bombshell. Please come.
I have seen that.
Answer, my lord, has seen?
Yes.
As far as pricing is concerned,
yes,
we
I have
declare
seen that.
entire tender goes. My lord, why does it go? I'll show your lordship. Please come to, my lord, the letter of acceptance of tender. Please come, my lord, to. Please come to internal page 16 of the compilation just once. Please bear with me. Absolute open and shut case.
Yes.
This is his material service contract. So this is the award given to him, to L1. Please come to the bottom. Please come to the bottom. Item code, my lord has seen. Item description, sulfuric acid, technical grade, 98% weight by weight, minimum so and so. Quantity, 2500. Unit of measurement, ton. Rate, 3400.00. Which means this is a fixed rated contract. And now come back, my lord, to that mail. They say we have no guarantee whatsoever of supply at any rate. We will take whatever rate we want to. So this negotiation is happening between Shiladitya Chakraborty of PDCL and the manufacturer, who refuses to say that we are giving it at a fixed rate. Before that, Mr. Shiladitya Chakraborty's institution has handed over the contract on a platter to L1, who at that point of time had an authorization only for 6 months.
I followed it. Yes.
Criteria. As it fell from your lordship, the first question, your lordship, that is he is an authorized representative and he does not need that. Secondly,
who is the authorized representative?
Sudha Chemicals, your lordship. The tenderer, your lordship.
Who he is appearing for? Who is
The
it?
tenderer who
He's
has been awarded the contract.
He's PDCL.
PDCL, I am appearing
He's
for PDCL, your lordship.
Yes.
He's supporting Sudha.
He has given the contract. He has been given the contract, your lordship.
PDCL has given contract to Sudha.
Sudha, your lordship.
Yes.
And now there was a
Sudha has a letter of authorization
Sudha had a
from
letter of authorization to participate in the contract, your lordship, that was
relying upon this authorization, and these are the documents which you have handed over today.
Lordship, this.
There is no mentioning about the price and the period for which the sulfuric acid will be supplied to the to Sudha.
It is in the contract, your lordship. It is in the contract. The main contract, your lordship, it is there in the contract.
If the person
it will be covered. It is in the contract, your lordship.
No,
listen,
has your lordship?
the person who is giving the authorization clearly mentions that they are not sure about the pricing.
Pricing.
They cannot give you any guarantee about the pricing. Right?
Lordship?
What, you are getting some instruction?
No. I'm not getting the instruction. It is a fluctuating market, Your Lordship.
Exactly.
It is a fluctuating market.
You have to be sure about the rate because that is your tender document. There is a fixed rate mentioned. The market is fluctuating. If the person who is providing the sulfuric acid cannot give you the rate, the guarantee of the rate, then how can
Cancel,
you?
Your Lordship.
In
the
the
entire
midst,
contract goes because
in
he is the L1.
Your idea is to sustain the contract for a particular period, and not to cancel it in the midst. You'll go for a fresh contract. What is going to happen? This will incur extra costs.
Cost, Your Lordship.
Then why will you give the contract to somebody who is so inconsistent with regard to the pricing?
He will give, Your Lordship. He is giving, Your Lordship, at the lowest rate, Your Lordship. I have just annexed the tax invoice and
What is the rate now that he is giving?
Chaudhary.
34 is your rate. 3,400
3,400
is your rate.
Rate.
Suppose the rate increases.
He has to give it. He is in that rate. He has to give it. Why?
He has to give which rate?
There is a price variation clause also. There is a price variation clause. And Your Lordship, there is a...
What is the rate quoted by the petitioner?
L1.
L4?
He is the highest.
How much? He is the manufacturer.
Your Lordship, yes.
ফিনান্সিয়ালি ঢুকেছিলাম
ফিনান্সিয়ালি তো একসঙ্গে আপলোড করেছি আমি কত
ফিনান্সিয়াল বিলটা দেখান আপনি আরে আমাদের ডকুমেন্ট আরে বাবা he was the highest. Lordship, this was done in a...
Did the petitioner get the chance to put in his financial bid?
Yes, Your Lordship. This is system generated.
Blindfolded within 3 minutes.
The technical bid is opened, Your Lordship. Suppose I am 3 friends are qualified. Then it is in the union. This is portal is conducted by Union of India, Your Lordship. That is given. It is automatic then.
All right.
It is automatic. Now we don't have any
control over it.
No, we don't have any control over it.
All right.
Once it is given, we have to.
What is the rate quoted by the petitioner?
It is the L4.
How much did you quote? How much did you quote? 3,400 is the lowest bid. The manufacturer, usually it is the manufacturer who quotes the lowest rate.
Yes.
Because otherwise, what is the
not at all
purchase, profit, transit cost, everything gets added
because of the super profit.
Oh, is that
Yes, it can happen, Your Lordship.
It can happen. Yes, the court is not going into all these things.
Secondly, Your Lordship. Secondly, this is generated, say, from the portal itself. That he is the higher bidder. I have to just see the 3 volumes, Your Lordship.
I am only on
this
one.
Was not considered. He is the.
My lord, I am only on one thing. That
the highest bidder.
The day they sealed the fate of L1 and said, I am giving you the contract. On that particular date, L1 was deficient. Mr. Shiladitya Chakraborty, after a month, is personally communicating with the manufacturer. Even the response suggests that L1 is still deficient. If today L1 has sustaining a loss, made 2 supplies in order to show that they have started, does this cure the vitiation?
No, but then if they can continue with the same rate, right? As you said, sustaining losses.
No, my lord, for once or twice. Once.
PCL is not going to give him extra facility.
Shudha is not there. Shudha is not there. Shudha, after getting service of the writ, has chosen not to appear. Shudha is watching from the wings. PDCL is supporting Shudha as it would. Now, in supporting Shudha, what does PDCL have to do? Show that the processual terms of the tender were complied with and non-essential terms were not violated or negotiated.
What is your bid?
My lord,
I've relied on the judgment of the Supreme Court in this matter, Your Lordship. In the contractual matter, if it is not malified and for the interest of the public, the court should be circumspect.
Sai was 2.73, theirs was
26.
Money chemicals. 2.6 or 2.4 something. Lord, it's not absolutely clear. What I'll do is, Lord, let me come back with a supplementary. No, I'll tell your lordship why.
No, see, tender matters, the court usually do not enter into all
With,
these
with an
things.
interim order, court doesn't. Here, my lord was pleased to direct them. Please show your papers from where it will be seen that there is no violation of any of the eligibility conditions. From the papers shown by them, if they are strewn together and interpreted, it is aptly clear that there was a violation of eligibility condition of technical bid, which had a snowballing effect on the financial bid.
No, but then
this is your lordship to turn to page 74.
My lord, I just have only one prayer.
Of justice, your lordship, for the lowest bidder.
Listen,
Our endeavor is to be lowest, get it from the lowest bidder.
But get it means you need to get it for a particular term, not that you get it for only 2 months and then 8 months it goes.
It won't go, your lordship.
It won't go.
If
size the supplier, the supplier is Shudha,
it goes, your lordship.
Manufacturer is Khoitan. They are not sure. WBPDSL is sure.
It's different. What about your losses?
My losses.
How will you function without the supply of sulfuric acid?
I am protected by the contract. There is a clause, your lordship, in it, lordship. I will show. Give me some time. Give me half an hour's time. I'll see.
Half an hour?
My lord kindly does this. My lord kindly does this. I'll tell you, lordship. My lord, their back is to the wall. Kindly give me an opportunity to file a supplementary within a day. I'll come back.
Then I am filing an application.
My lord, I'll come back. No, let me show Supreme. My lord, only one thing. A supplementary affidavit within such time.
Applied before the authority and they have rejected your...
As far as the rejection is concerned, my lord, I am saying that the rejection is especially bad. That's my writ. That's because the eligibility conditions of L1, L2, L3 have not been met. They have not been met, and that is why every one of them has been made a respondent. This is a comprehensive writ. It's not a round one writ where I say I don't have received, I have not received information. I say that.
All right.
So, my lord,
but then
my lord, only one thing. Only please, my lord, one supplementary affidavit. One supplementary affidavit.
Supreme Court, your lordship, 52, 53, and 54.
Just one supplementary affidavit. Not may I come back with a supplement?
What will you put in your supplementary?
Just my lord, screw the things together in order to show violation clause wise. If I fail, I am out. If I succeed, they should go out, my lord. I'll just put it in the form of a supplementary.
Particularly paragraph 53.
Lord, I have judgments galore. Also, every judgment turns on its own facts. Let the facts be cleared.
No, this is the judgment, your lordship. This general proposition has been laid down. It is quoting the very often quoted, your lordship, judgment of Air India judgment has been quoted here.
Air India subsequently explained.
It can choose its own method to arrive at a decision. Paragraph 53. Decision it is free to grant relaxation for bona fide reasons, your lordship. And LI is a
only one thing. Please give me a supplementary affidavit, Lord.
No,
I'll just come, Lord. Kindly let me deal with these documents. Please let me deal with these documents, Lord. I don't have any recourse then.
The petitioner participated in a tender process and was unsuccessful. A representation was made before the respondent authority, which stood rejected. Hence this writ petition. The primary contention of the petitioner is that the L1 bidder did not fulfill the minimum eligibility criteria to participate in the tender process. The documents relied upon by the L1 bidder at the time of submission of the bid are not consistent with the terms and conditions of the tender document. According to the petitioner, the L1 bidder has not been able to produce a proper authorization letter from the manufacturer of the good that is to be supplied. The rate relied upon by the L1 bidder does not appear to be a fixed one, as the manufacturer company from where the L1 bidder will purchase the good has not vouched upon the pricing. Stop paragraph. It has been submitted that the petitioner is the manufacturer of sulfuric acid and is in the best position to supply the acid at a marketable at a competitive rate throughout the entire contract period. Stop paragraph. Learned advocate representing the PDCL. পুরোটা লিখে দেবেন তারপর ব্র্যাকেটে PDCL লিখবেন submits upon instruction that the authority has confirmed that the L1 bidder will be in a position to supply the good for the entire contract period at the rate as mentioned in the tender document. Stop. On being satisfied, the contract has been issued to the L1 bidder. Stop. Reliance has been placed on the judgment delivered by the Honorable Supreme Court in the matter of Tata Motors Limited versus Brihan Mumbai Electric Supply and Transport Undertaking and others, reported in 2023 SCC Online SC 671, wherein the court was pleased to hold that ordinarily a writ court should refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of a tenderer unless something very gross or palpable is pointed out. Stop. The court ordinarily should not interfere in matters relating to tender or contract. Stop. Paragraph. Upon hearing the parties and on perusal of the documents, no glaring defect and or inconsistency has been brought before this court requiring interference. Stop. Next. In view of the above, no relief can be granted to the instant petitioner. Stop. The writ petition fails and it is hereby dismissed. Stop. The tender issuing authority shall, however, ensure that the L1 bidder is in a position to supply the required good in terms of the tender document for the entire contractual period.
Deeply obliged. There's only one submission I had, my lord. I have
Yes.
before your lordship, my lord, from this document that the
And no
same-
further possibly, there is hardly any chance. Take your chance before the higher forum.
The only that thing that I pointed out to your lordship, my lord, that the same document of 24th of June has two avatars.
Yes,
One
I
which
have
was
seen that.
uploaded and one which was given. So
Right.
on the face
Yes,
of it,
call
my
the
lord,
next one.
And for the state.
Petitioner? Yes.
obliged, lordship.
My lord, this is the matter, my lord, where a lady wants to go to USA. And I request your lordships to come to page. The order passed by your lordships in the earlier round of litigation at page 50.
Yes.
I kindly go through your lordship's own order. That order was passed on 28th of November 2024. Prior to that, on 27th November, the matter was taken up by your lordship,
Right.
when an adjournment was paid on behalf of the passport authority.
Mhm.
And the matter was fixed on 28th, and 28th, the matter was disposed of with certain directions. But after disposal of this matter, the petition was served with page 56. A show cause notice. It's a predated, dated 27th of November.
All right.
This was not disclosed before Lordship at the time of hearing on 28th of November. A show cause notice was issued why my passport would not be impounded. Now, the petitioner was compelled to move this court once again, page 59.
Yes.
Now, there was remarks that this is a vindictive attitude as well as egoistic attitude on the part of the respondents. And that was stated by this court. With a further directions, kindly come to page 61, my lord. 61 first paragraph. 60 last paragraph, let a report in the form of affidavit be filed by the respondent authorities within fortnight from this date. In the said report, the regional passport authorities would provide a chart for the last 1 year of all cases where police clearance was issued or not issued against individual having pending criminal cases. That was the situation. Now, page 62. Kindly have a look at the date, 1st of January 2025, the New Year gift for me. And kindly have a look at the number of this order number, left hand side 17, within bracket 1165. Now, this was passed rejecting my claim to issue police clearance certificate without paying any heed to the observations made by this court, by your lordships on the last round of litigation. That's why I request your lordships to go through your lordships' own judgment at page 51. The observations made by your lordship.
All right. The direction was to consider issuance of PC, police clearance certificate.
In the light of the situation that the NOC that was passed by the jurisdictional magistrate. Now, they said some incorrect statement was made by my client at the time of making application for police clearance certificate regarding pendency of case, despite of having the NOC from the police authority, from the magistrate. They rejected. On the very date, kindly come to page 64, the self-same authority. The self-same authority. The date is 1st of January 2025. Page 64. And left-hand side, my lord, the order number is 171388. That shows that rejection was first and then this was issued.
Cancellation of show cause and requirement
Yes,
of documents.
that show cause notice which was, my lord, stated by this honorable court, that was cancelled. Why? Because they was directed to, my lord, file a report indicating the number and details of the persons for 1 year. What they said here, my lord, kindly have a look to page 64. 64 and the 63, that's, my lord, contradictory. In one hand, it says it scraps my application, and page 64 says you apply. And they also indicated the notification.
When that actually exists successfully.
In my rejection, they didn't mention this 25th of August 1993 and subsequent notification of 2019. Even they didn't mention about that. They didn't mention about your lordship's observation. They decided, yes, we have to reject it, and they rejected.
Criminal proceeding in pending is incumbent upon you to fulfill this remote telling regarding availability by passport will part the clear mentioned your honor. Thank you. Page 64.
Yes, my lord.
You have been directed to appear for appear.
Hence, you are requested to visit this office in person along with original passport on
Submit
any
the
working day between so and so to submit the certified copy of the order from the trial court pertaining you to. But now, if 63 is the 62 is there,
No.
then why 64?
1 minute. Passport authority is not in a position to certify if the PCC has suppressed. PCC application is not allowed. However, agreeable.
And I have the passport. I am not asking for passport.
I haven't gone through the evidence and decided the following. What does it mean? Page 62. Let me understand.
And
please.
one thing, my lord, kindly. Now, they kindly 64, they have referred to as GRS dated 25th of August 1993.
Yes, GR.
That is at page 65. That was ultimately, my lord, modified to some extent. And the new one is 68, page 68 of 2019. I am covered by that. I am not a businessman. I am not a politician. I am just a lover. And that is standing.
Yes.
Love is not a crime.
No. Thing is that.
Well, kindly come to clause 5. Clause 5 at page 69. The detailed process. Even if person don't have passport is to be, my lord, issued in his favor.
Clause 5, which portion you want to rely upon?
Clause 5, it's a process. They say, now kindly come to I.
I means
6,
1.
7, 8. I'm sorry. Yes. 4, 5, 6. My lord, kindly come to 6.
VI.
VI.
In case the secondary police report
If
is
the
also
details
adverse.
given in the police report and the undertaking submitted by the applicant are mentioned, then the no objection certificate issued by the court of law submitted by the applicant would take precedence over any adverse report submitted by the police. In such cases, the adverse report may be overruled with the written approval of the passport officer.
Where did you read? I cannot find.
Page 70.
Page 70, VI.
Yes, VI.
Yes.
VII. I'm sorry.
VII.
Yes.
All right. If the details nobody. Yes.
In my case, that NOC is there. That was
no NOC was possibly there was some problem with the NOC. Show the NOC one.
Yes, my lord. Kindly come to page 45.
45.
It says there is no objection from the public prosecutor, and the report, the RTI report shows no other criminal cases pending against me. Last 3 lines.
The court finds no impediment to allow hence the petitioner is considered and allowed with the consent of the learned prosecution. So the court order is in your favor.
Yes, that was taken care of by your lordship.
All right, let me hear once.
Your lordship's order at page
55.
Yes.
Para 22.
Right.
Hence, the instant writ petition is disposed of by directing the 7th respondent, the regional passport officer, to consider issuance of a police clearance certificate in favor of the petitioner in light of the observation made hereinabove. The decision shall be taken in the matter at the earliest, but positively within a period of 4 weeks from the date of communication of this order. Now, what my learned friend is trying to impress upon is there are 2 orders, and he is submitting that is conflicting orders. Now, kindly come to that first. The first one is at page 62, which has been read out. Now, it has a detailed, this is of 1st January 2025. Thereafter, your lordship's orders was passed, this was issued. Now, here, the explanation has been given by the passport authority.
Which one is the first one? Is it 62 or 64? Both are dated 1st of January 2025. From the numbering, it appears that
65 is the way GSR. 65 is the
No,
GSR.
64.
64.
Yes.
Both are dated
Now,
1st of
there
January.
was a mistake and it has been reviewed. In 64, your lordship will kindly find
Yes.
it is in reference to the so-called notice dated such and such. In this regard, it is mentioned that the matter has been reviewed by this office in context with the provisions of the notification GSR, and the aforesaid notice stands cancelled and withdrawn forthwith. This is for
So page 62 is withdrawn.
Yes, that is there. Now comes the question whether the passport authority can grant a police clearance certificate. That is limited to this.
No. 62 was not withdrawn.
Milord,
No. But something wrong. My lord. May I? The reference.
Please wait.
Reference goes to page 56.
Please wait.
Reference goes to page 56.
Stands cancelled and withdrawn forthwith. That is the language used.
The matter has
However,
been
since
given-
criminal proceeding in respect of the case being such and such are found to be pending against you, it is incumbent upon you to fulfill requirement under the provisions of the aforesaid notification. It is to note in this regard that validity of your passport would be at par with the period mentioned in the order. In case no period is mentioned in the order, passport would be issued for a period of 1 year only. That is in terms of the GSR
Yes.
of 93. Now, then kindly come to the next one, which is the impugned order now in the writ petition, whether the passport clearance certificate can be issued by the passport authority. That has to, passport authority is to act in terms of the GSR.
There is a court's order, no objection.
I am not going into that issue of
No, tell me, without going into the issue whether the passport authority can issue no objection or not, we are not going to that. There is a court's order granting no objection. Why doesn't the authority act in accordance with the court's order?
My lord, court's order of no objection has been granted in terms of a pending criminal case.
Yes.
Now, his cause of action now is in terms of an issuance of a police clearance certificate. After this, where the passport authority is to verify whether any other criminal case is pending. Now, the passport authority has explained their conduct by annexing the GSR that provides, my lord, there are three actually, kindly come to page 66.
The court, the learned magistrate, possibly
It is a
mentions
consent order by the public prosecutor.
that is the
Consent order by the public prosecutor.
where is the problem?
Well, the question
There is no problem at all even if it's a consent order.
if your lordship kindly looks at the GSR once in the list,
yes,
your lordship will kindly find the guidelines there. At page 66.
Consent orders are not orders of court.
Yes.
Then
But that is at page 66. Kindly come to page
did
66.
the police find out? You will not be able to know. Is there any adverse report before you that there is any other criminal case?
No, I have no.
No, page 35, that certificate I have annexed.
Nothing is there.
Nothing.
What is the problem?
Kindly once find this page 66.
66, yes.
What is the guideline under which section 6 to F can be modified? The passport to be issued to every such citizen shall be issued for the period specified in order of the court referred to above. If the court specifies a period for which the passport has to be issued. Secondly, if no period, that is 1 year. Then thirdly, if such order gives permission to travel abroad for a period less than 1 year, but does not specify the period validity of the passport shall be issued for 1 year. They kindly come to D. Clause D. The said citizen shall give an undertaking in writing to the passport issuing authority that he shall be, if required by the court concerned, appear before it at any time during the continuation in force of the passport so issued. This is the passport authority wanted him to do. And he made a representation. Let that be disposed of by consideration.
1 minute. 1 minute. Where is the representation that can be disposed of?
Yes. That is your lordship can kindly find at page.
Undertaking was given earlier also.
Before this court
What?
also, that was recorded.
Before the court and it was recorded, right?
The commissioner indicated that no other case is pending against me. 7 except
1
this
minute.
one.
1 minute. Tell me where is any.
That is, my lord, your lordship will kindly find.
Is anything pending before the
No,
authority? No.
that was pending. That's why your lordship's directed to take decision, and that decision has been taken by rejecting.
Police clearance certificate can be granted by the passport authority.
I will
Under
keep this. I will keep this writ petition pending.
That was the specific argument on their behalf.
The writ petition will be kept pending. Let the passport authority take steps in the matter. Please come. Where does the petitioner want to travel?
Or USA.
The petitioner intends to travel to the United States. Stop. She is not being provided with the visa.
Due to non-issuance of police clearance certificate by the passport authority.
As the police clearance certificate cannot be issued in her favor on account of pendency of a criminal case. Stop paragraph. the petitioner has been able to obtain the order from the learned magistrate recording no objection if the petitioner is permitted to travel abroad. Stop paragraph.
But my lord, the declaration which is required on the GSR has not been given to the court, criminal court.
I was never asked to do so.
Acha.
Without hearing me pass that order.
The petitioner, the petitioner's prayer for issuance of visa has not been allowed. Stop.
Order
The learned.
my prayer for visa that is to be taken care of by the USA. Now that is not being finalized due to non-issuance of PCR by the PCC by this passport authority.
Petitioner's prayer for issuance of visa has not been allowed.
No, cannot be taken up for consideration because of the non-issuance of the
Police clearance
police
certificate.
clearance certificate.
By the police, by the passport authority, regional
How
passport
can the passport authority issue a
That-
PCC?
yes, that argument was made. That argument was made on behalf of them on the last occasion.
Yes, it cannot. So that is not the issue. Right.
Only in case of USA, the police clearance certificate is to be issued by the passport authority, and that was admitted by them before your lordship.
Acha. The learned ASGI submits that an undertaking is required to be given by the petitioner in terms of the GSR number 570 within bracket caps E, dated 25th August 1993. ঠিক আছে? Paragraph. The petitioner categorically mentions that she was never asked to submit the undertaking before the passport authority. Stop. The petitioner has given such undertaking before the magistrate and also before this court. And the same is recorded in the order dated 10th of December 2024 in WPA
28th of November, your lordship, before your lordship.
Acha, which page? Acha,
Page 50.
28th of November. 28 November 24 in WPA 25175 of 2024. ঠিক আছে? Paragraph. As it appears that the petitioner is frantically wanting to travel abroad, but is not being provided with the supporting documents. Accordingly, the court intends to keep the writ petition pending. Stop. The passport officer is directed to intimate the petitioner the formalities that she is required to comply by today is 27th, by 7th of February. Stop. The matter is made returnable on the 17th of February. Stop. Necessary steps shall be taken by the passport officer positively prior to the adjourned date. Yes, call the next
Great,
matter.
ma'am. Affidavit of service be kept.
Yes, service is taken on record.
But I appear and get the petition.
Your lordship, I appear on behalf of the respondents.
The immediate concern is the inaction on the part of the respondent bank by sending recovery agents, and they are claiming unauthorized amount.
Unauthorized
Unauthorized amount.
amount.
My lord,
Why are you here? Proceedings under the Surfacy Act.
lordship, the thing is this: the recovery agent,
Hmm.
they are saying they are coming into the borrower's residence, harassment, intimidation, everything. And the most troubling thing is this: I take 9 lakhs rupees of loan and paid 52 installment in the meantime, and they are asking the 19 lakhs rupees. They are in their affidavit itself. They have
The
stated
figures,
that
the calculations, nothing will be gone into proceeding under the Surfacy Act. You are aggrieved.
only
Are you the borrower?
I am the borrower.
So you've got a very good right to prefer proceeding before
Only giving
Surfacy
only
Act.
give me the breathing space, my lord, and the restrain the recovery agent from harassing and intimidations. My lord, the latest judgment.
How much is due?
Your Lordship, I have been assigned with this matter, Your Lordship, in the morning. We have not been even served with the petition.
Not served with the
No, Your Lordship.
Petition has been served, my lord.
Your Lordship, kindly direct them to
Give soft copy at least to him.
Soft copy all that.
So you are not ready with instructions
No,
as to
Your
how
Lordship.
much is due?
No, Your Lordship. I have to take instruction
Affidavit,
from
if
my
your
client. Your
lordship
Lordship kindly keeps it any day after 2-3 days. Your Lordship will come back with instructions.
Yes, and in the meantime, are you sure you will not take steps for
Your
selling off the
Lordship, we have.
property?
No, Your Lordship, I don't think so that will happen. We have to take instructions.
What don't thinking will do?
They are
Where
going
is
to
your
take
power?
possession of my property.
Your Lordship, we have been assigned with this case. We have just received the mail relating.
Receive the wakalatnama?
Your Lordship, we'll do it today, Your Lordship. Just we have received the mail relating to the representation. We'll file everything today, Your Lordship. We have not been even. I didn't even get the petition, Your Lordship.
But at least an interim protection, my lord. I should not be dispossessed from my residence. The recovery agents coming. They're saying the court's order is there.
I personally, I'll just
Listen,
go down.
try to understand one thing.
Yes, Your
You
Lordship.
can feel the predicament of your learned senior friend,
Absolutely, Your Lordship.
right? When your client gives you the instruction, this bare minimum instruction ought to have been given as to whether they are taking any steps for throwing out the petitioner from the secured asset or not, first. Second, and that is the reason why the matter is there in the list as urgent motion. So the urgency you can understand. What is the instruction? You didn't take any instruction. Only to appear, adjourn it for 2-3 days, and in the meantime he will be thrown away. What
No,
is
Your
going to
Lordship.
happen?
Your Lordship can keep it tomorrow. Also, we will come back with instructions. But if they provided the server copy upon me, I'll surely do it, Your Lordship.
And the court's time is all along there. Whenever you choose,
I
the court
apologize
can
for the
list matters.
mistake of my client, Your Lordship. I
Let
am
them come up with
apologetic,
the
Your
report
Lordship.
by way of affidavit, my lord. In the meantime, providing all the documents, the basis
Please
of the
come.
claim, and then interim protections, my lord.
The petitioner alleges that the bank is threatening to dispossess the petitioner from the secured asset and is adopting illegal measures to intimidate the petitioner. Stop paragraph. The learned advocate representing the bank seeks time to take instruction. Stop paragraph. On such prayer, the writ petitions, prayer hearing of the writ petition stands adjourned till 31st of January. Stop. Written instruction shall be obtained by the learned advocate representing the bank and be placed before this court on the adjourned date with an advance copy to the learned advocate representing the petitioner.
Much obliged, Your Lordship.
The learned advocate for the leave is granted to the advocate of the bank to file the wakalatnama in the department by course of tomorrow. ঠিক আছে? The bank is restrained from taking any coercive step against the petitioner till 31st January 2025 or until further order, whichever is earlier.
I'm grateful.
Grateful, Your Lordship.
To mention, Lordship, this
service is taken on record.
This court had granted me leave on Friday to file this matter, but unfortunately, for some fault on part of my clerk, it couldn't be filed within that course of day. If Your Lordship could give me leave that it could be filed within course of today.
The leave was obtained, but thereafter nothing happened.
No, the leave was obtained. The registrar had duly signed it. I gave it to my clerk to get it filed, but for some
file করা যেতে পারে তো? ঠিক আছে, it will be listed on Wednesday. File it and serve.
Grateful.
My lord, in item number 6, my lord, Mr. Kollol Mondal is appearing, my lord, due to some, for the petitioner, my lord, due to some medical exigencies involving his wife, my lord, he couldn't come to court today, my lord. My lord, kindly makes it not this week, my lord.
Not this week.
My lord,
It's appearing as upgraded motion.
yes, my lord. At least, my lord, not today, my lord.
Not today and not this week means a lot of difference.
Yes, my lord.
Then?
I know, my lord. Kindly makes it not today, my lord.
Did you serve?
Yes, my lord. It has been served, my lord. The advocate for the state was present, my lord, before the break, my lord. Recess, my lord.
If you want it not this week, then not this week. Accommodation has been sought for by the learned advocate representing the petitioners. Stop. On such prayer, the matter stands adjourned for this week.
My lord.
Service in the meantime.
Service has been done, my lord.
Very well. If it is done, it is done.
My lord.
But in this matter, I appear for the petitioner.
Yes.
There are two affidavits of service, my lord. One is respect of service of the writ petition, and the second one is in connection with after upgradation as per your direction of your lordship.
And I'm appearing for respondent number 6, which is the centralized receipt and processing center of RBI. Respondent number 5, civil.
But the grievance of the petitioner is that the
1
petitioner.
minute. Respondent number 5, you are there. Civil. And Bank of Baroda? Who will be the answering respondent? Civil can answer.
Only bank can answer.
Only bank can answer.
Some prayers are sought for against the civil as well as bank. But there is no relief sought for against respondent number 6, whom I am representing before your lordship. Your lordship looks into the prayers.
The affidavit of service after upgradation has been filed before your lordship after serving the bank.
Where is the upgradation? Oh. Yes, what is your prayer?
Mother, my prayer is, my lord, this is the second time the writ petition has been filed. The previous writ petition, there were certain directions upon the bank to be complied with. Now, purportedly, something has been done, but not to the satisfaction of the petition.
Show me the earlier order.
Yes, your lordship kindly turns to page 66, but the relevant is page 67. May I read out? But from paragraph 5. Page 67, relevant page 66 starting. But from paragraph 5, may I read out? Although it transpires that written off and settled status have been mentioned under the same caption in the said guidelines, upon hearing learned counsel and going through the said guidelines, it transpires that there is a qualitative difference between a loan being written off and being settled. In the first case, the expression written off indicates that the entire loan has been written off in the absence of any further qualification of the term. However, in the event a loan is settled between the parties, the two components are to be indicated separately. The portion which has been paid by the borrower is to be shown as settled, and that which has not been written off by the bank is to be shown as such. There is no reason why the same principle should not apply to the present case, as the petitioner had entered into an one-time settlement upon which only a portion of the loan was written off and the rest was settled. It is evident that if a portion of the loan is settled, the status of a petitioner ought to be on a higher footing than if the entire loan amount had to be written off. Keeping in view the above consideration, WP disposed of by directing the respondent number 1 bank to communicate to the civil authorities within a week from date the request of the respondent number 1 bank to modify the credit facility status regarding the loan amount which has been settled between the parties by way of one-time settlement, to the effect that instead of the expression written off, the same will be depicted as part settled and part written off. The bank, if so chooses, can also indicate the respective quanta of the amounts settled and that which has been written off separately. Now, after this order was passed, The bank, we do not know what the bank did, but the CIBIL grading was not upgraded. That refused the petitioner to apply for a second time educational loan for his daughter. Now, for that purpose, we came up with a contempt application. In the contempt application, if your lordship kindly sees, the Honorable Court directed that since CIBIL was not present, it should be made a party. Our contention was that CIBIL is only a central agency. It gathers the data are uploaded. It gathers into its server. Anybody other than the concerned bank, is financial institution, wants to get in touch with the CIBIL gradation, they can do so. Now, since that gradation was not upgraded by the bank's direction, CIBIL could not do anything. They are only just carrying forward. Now, for that reason, the contempt was Mr. Honorable Justice Shobhrachi Bhattacharya, while dealing with this contempt application, dealt with that CIBIL should be made a party. If your lordship kindly sees page 76, paragraph 4. However, I find from the order in has my got it. Page 76, my lord. The order passed in the contempt.
1 minute. What is your contention?
As per Act, my lord, CIBIL suo motu has no discretion.
Did the bank intimate you with regard to the settling off and the payment made? Nothing. Do one thing. The bank was represented on the last occasion by 3 counsels. The names are there. Serve a notice on them. Let them come. Otherwise, it will be difficult. Please come.
The advocate should be...
Yes, advocate. None represents the bank, despite service. Affidavits of service filed in court be retained with the records. Stop. The presence of the bank will be required for effective disposal of the instant writ petition. Stop. Let notice be served upon the learned advocates who represented the bank before this court in the earlier writ petition filed by the petitioner. Stop. Learned advocate shall take specific instruction with regard to compliance of the direction passed in the order dated 12th of March 2024. Stop. The written instruction shall be obtained with regard to the quantum of amount which was treated as written off and the quantum which was settled by the bank in connection with the one-time settlement entered into by the petitioner with the bank. Stop. List the matter on 7th of February.
But subject to my lord's kind sanction, let the order be uploaded so that I can take a server copy of the same and serve it also along with my notice. Subject to my lord's kind sanction.
Order.
The order your lordship just passed now.
It will certainly be uploaded.
No, sometimes we find it delayed.
No, it will be uploaded. Don't worry.
Much
Item number 8.
My lord, I appear for my lord the writ petition. On the last occasion, my lord, the argument was made that whether Section 6 of the Passport Act, my lord, creates any embargo in respect of a citizen, my lord, against whom a criminal proceeding is pending. Now, my lord, FIR has been lodged, no charge sheet. I have relied upon a Supreme Court judgment. Even then, your lordship was kind enough to prima facie observe that why my client did not make any application, online application as required under the law. My lord, my client has made an attempt on instruction I am submitting, my lord, but we are not accessible. They are not giving access us because of this pendency of the criminal proceeding. The portal, my lord, was not accessible to us. That is my instruction. My junior is there, my lord. And unless and until, my lord, they allow me to, my lord, apply. How I do not know, my lord, whether there is any lateral entry, my lord, to make such application. That is why the representation was made. My lord, 29th March 2025 is the date of expiry. My lord, the order of the authority passed as a sequel to the order passed by the Honorable Justice Bhattacharjee, Milord, in a different matter. Milord, Honorable Justice Bhattacharjee, Milord, while Milord deciding the issue, was kind enough to observe that the decision which I relied upon, bench presided over by Justice Nageshwar Rao, Milord, this is a judgment under Article 142. Possibly, Milord, the last two paragraphs of the judgment which I relied upon on the last day, Milord, it is a clear interpretation of Section 6 and it leaves no room.
Yes, Mr. Bose.
I'm sorry, Milord. Milord, my submission is because your lordship wanted me to apply for renewal. Milord, I'm instructed to submit, Milord, that portal was not made accessible to my client. My junior is there, Milord.
অ্যাপ্লিকেশন স্যার করতে গেছিলাম আজকে জমা নেই ওখানে
If your lordship keeps it pending, Milord, and I ask them, Milord, to allow me to join, Milord, apply, I hope, Milord, that the issues can be resolved.
What is his submission?
There is no appointment in the system that they try to file the application online.
No, this came later on. After the filing of the writ petition, this has happened.
Yes.
This is an undertaking which the petitioner intends to upload, but she cannot.
On the last occasion, the argument was advanced on our behalf was that there is no provision in the Passport Act or the rules for extension of permit, and even if it is an application for renewal, a fresh application has to be made and the earlier passport goes. Has made a representation. Kindly give him a liberty to make an online application.
No, online application submission cannot be made because the portal is not opening.
For everybody, portal is opening. In this case, why the portal is not opening, I do not know.
That I will not be able to say why the portal is not opening.
Grant them liberty to make the application.
Milord, my learned senior friend, Milord, possibly, Milord, but my client has instructed me to, my advocate on record, that this has actually has happened.
This has happened?
That is why my learned advocate on record, Milord,
not opening.
so.
Yes,
the portal is not
yes,
opening.
Yes.
I do not know.
He was unable to join, my lord. He was unable
And
to
is
apply
there any reason as to why the petitioner was unable to join? Because of technical glitches?
because pendency of this writ petition, my lord.
Pendency of the writ
Yes, my lord.
petition?
Yes, they are not accepting this. They are not giving any receiving copy because of this writ petition. They are asking that the writ petition is pending. Now we cannot proceed with the same.
That is a submission being made without any amendment in the writ petition.
Which was the
Make the application anew, online. We shall instruct them to accept it and decide in accordance.
Milord, Milord, I tell your lordship, if this Milord argument and counter argument of my learned senior friend goes on, it will not resolve the issue. If your lordship kindly ask my learned senior friend by using his good office to depute one officer who will render assistance, and my client will go there and Milord will try to apply through him, Milord. Only, Milord, this can be done. My learned senior friend, Milord, has immense influence over his other officers, and for this, Milord,
I don't have it. All clients are same. Kindly grant, Milord, the issue will be resolved. Kindly grant them liberty to make. We shall instruct them to accept the online application and decide it in accordance with it. And we cannot decide the representation which has been made. They have made a representation for renewal of the permit.
Yes, yes.
Milord, if the portal is not accessible, Milord, then this submission, Milord, some officer must take responsibility. my client will go there.
Hundreds of cases, portal is open. The passport is being
Where is your application for renewal? Please show.
Page 35, kindly come to page 35. We shall consider it then.
No, consideration will not do. Please come. The petitioner seeks renewal of his passport. Learned Senior Counsel, Learned ASGI, submits upon instruction that the petitioner is required to make application online for renewal of passport. Stop. It will be open for the petitioner to apply online for renewal of passport. Stop. In the event such an application is made, comma, the same shall be considered by the authority in accordance with law. At the earliest, but positively within how soon?
3 weeks.
Achha, within a period of 4 weeks from the date of filing the application.
Subject to compliance of all formalities under the rules.
That is all right, provided he is able to upload it. If he cannot upload, then I do not know. Achha. Stop there. The petitioner shall be obliged to comply with all the statutory formalities for renewal of the said passport. The writ petition stands disposed of. Take this back, no use keeping it. Nine and 10.
Your Lordship, Mr. Himanshu Dey is appearing in this matter. He is leading us. He had mentioned before Your Lordship on Friday. For some reason, he is not present in court. May I just humbly request Your Lordship to...
When the matter is called on, the counsel is not here. And when it is not taken up, it's been mentioned on repeated occasions.
My Lord, may I just humbly request to have this matter heard on Friday? It will be done, my Lord.
I'll adjourn it till Friday, but then I do not know whether it will be taken up or not. It will retain the position in the list as and when it appears. An accommodation has been sought for by the learned counsel representing the petitioner. Stop. List on 31st, Friday.
So in that case, Lordship, if a not today is... kindly make it not today.
Only not today?
Are you sure?
Because tomorrow he won't be there.
He won't be there. Oh, no, my Lord. Friday it is. Friday,
31st.
My Lord, Friday.
31st. 11.
Item number 11, my Lord, I am appearing on behalf of the respondent number 10. And my Lord, in 12, my Lord, I am the petitioner in a contempt application, my Lord.
All right.
My Lord, I beg to appear on behalf of the petitioner. My Lord, your Lordship kindly take trouble to look at the order dated 6th of January 2025, my Lord. My Lord, the police authority, my Lord, without having any authority, stall my construction, which is admitted in their report also. Thereafter, your Lordship directed them, the inspector in charge of the police station, to file a report by of an affidavit. No copy was served upon us, I don't know. Instructions.
Lordship, for the stay led by Mr. Shuddho Devadok. So this is a affidavit of report.
Where is Mr. Adok?
Lordship, he is 759, Your Lordship.
And somebody is leading him.
She is already engaged in another courtroom.
Everybody is engaged. Give a copy. Otherwise, how will the other side know what is there? What is the submission? Mr. Bhattacharya, is somebody there here to collect the report of the police?
Yes, my junior is here, Advocate.
There. Go through it, see what is there. Otherwise, nobody will be able to know what is there.
In nutshell, my lord, I can tell your lordship.
No,
Suit was filed and a suit status quo order was passed. On the basis of that, IC stalled my constructions, which earlier report admitted. After seeing the order, your lordship directed the IC. So under which authority he is doing this for illegal?
Yes. Is there anything mentioned in the report?
Paragraph 5. Well, kindly see again the report says the civil court's order, which was earlier shown before your lordship.
Paragraph
4411223, my lord. 411 dismiss হয়েছে সুটটা।
What is the B schedule property?
Schedule property is at
B schedule.
B schedule property. B schedule property is paragraph 2, my lord. RS dag number 1034, LR dag number 1035. 411 dismissal order dismissal.
B schedule property is the property which belong to my client. My allegation, there are twofold allegation. Number one, the allegation of encroachment. That is the reason I file a civil suit. Second allegation, my lord, unauthorized construction. Your lordship passed an order, but in spite of that, the Pradhan did not take any steps. That is the reason for filing contempt.
What is the B? Is it demarcated? B schedule property, is it demarcated?
No, my lord, that is not demarcated. My lord, the contention of the private respondent is that I am raising unauthorized construction. Initially moved the civil court, granted ad interim. Subsequently, that was also dismissed.
There is an order at page 6 of the report. See, the defendant is restrained from raising any illegal construction over the B schedule property. Who is the defendant in this suit? 565 of 23.
Petitioner.
You are the defendant.
I am the.
Now, where is this B schedule property?
B schedule
just adjacent my
But
property.
how will the police get to know?
Yes, my lord.
B schedule
Your lordship earlier occasion specifically asked whether there is an order of police protection.
Yes.
State denies that. Says no, there is no. You have from the report also they are not saying that there is direction of police.
You do not know anything. No, your lordship. Obviously, this I can understand.
They have taken the help of one direction, my lord, in paragraph 4, my lord. If your
Paragraph 4.
of the
What is there?
report, my lord.
What is there?
Say that keeping in view of order dated September 16, 2022, passed by Honorable Justice Rashekar Mantha in WPS such and such, the Commissioner of Police Howrah shall issue suitable directions to all police stations to promptly and strictly implement all orders of the civil code.
This is not my petition.
My lord, I tell your lordship.
What is to be implemented?
My lord, I tell your lordship, my lord, I have the privilege to appear before my lord Justice Mantha in this matter, my lord.
Listen, Mr. Bhattacharya, I only want to know whether the B schedule property is demarcated or not. If it is not demarcated, how will the police get to know which is the B schedule property?
My lord, the police only requested them not to take any construction on the B schedule property.
How will the police know which is the B schedule property?
Because this is a civil court's order, my lord. This is a civil court's order, my lord. That is the reason. And my lord, the Justice Mantha's, my lord, on the earlier occasion, my lord, directed all the commissioner to circulate that the police should maintain all the code.
What is your client doing?
Oh, my lord, understanding of my client, my lord, kindly,
Yes.
my lord, report, my lord, page number 6 of my report, my lord.
Yes, page
My lord,
number
this
6.
is the order passed by the learned, my lord, civil court that the defendant is hereby restrained from raising any illegal construction over B schedule for suit property by
B schedule property is not demarcated. How will the police know which is the B schedule property?
my lord, definitely, my lord. I appreciate before your lordship,
Then-
my lord. I appreciate, my lord. My lord, this is the understanding of this police, my lord. Police, my lord, do not
If the
intention,
police-
my lord.
If the police is under some mistaken understanding, then what will the court do? And what will the parties do?
My lord, at the time of this, my lord, after my lord receiving of this court orders from the my lord, learned, my lord, my lord, from the petitioner, my lord, police, my lord, only my lord, police bound to my lord comply with any order by my lord civil court and by your lordships, my lord.
bound to, my lord, comply any orders, my lord. Lord, kindly, my lord. And my lord, page number 11, my lord, this is the one matter, my lord, this is the misunderstanding of this order, my lord. Page number 11, my lord, Justice Mantha order, my lord, the Commissioner of Police, Howrah. This is the last paragraph, my lord. Internal page 2, my lord. This is the, my lord, the Commissioner of Police, Howrah, shall issue, my lord, suitable direction to all police station to promptly and strictly implement all orders of civil court in letter and spirit of, my lord, right of honors. My lord, this is the misunderstanding of this, my lord.
759 of 2021. What is the order? Whose suit is this? 759 of 2021. Whose suit?
759.
Page 6 is TS 565. And page 11 is 759. Are they two different suits?
My lord. Both suits, my lord.
Filed by?
One filed by them, another filed by me. The suit filed by them was ultimately dismissed.
565 has been dismissed.
Yes,
Not dismissed, already.
565, Chayan Chakraborty.
Show me.
Orderটা বলতো dismiss এর injunction order dismiss করে দিয়েছো।
It's not in suit dismissed, injunction order vacated.
Injunction order vacated, my lord.
Injunction order is vacated. Yes, where do I get that?
Earlier officials handed over.
My lord, an appeal has been preferred, the appeal is pending.
অর্ডার থেকে ইন্টারিম অর্ডারটা আগের দিন জোসেফকে দেওয়া হয়েছিল, একটা কপি আমাদের কাছে থাকবে। দেখ
page 16, 14, 15. Yes, page 14, 24th of November 2023. Please come.
My lord, kindly come to paragraph page 4 of the order. Page 4 of the order, my lord. Last 8 lines.
A report has been filed by the police, wherefrom it appears that the police allegedly acted in terms of the order dated 19th April 2023, passed by the learned civil judge, Junior Division, 5th Court, Howrah, in TS 565 by 2023, whereby the defendant in the suit, that is, who are you, Chayan?
Yes, Chayan is Trisha Mondal is myself.
Acha. Whereby Trishna Mondal was restrained from raising any illegal construction over the B scheduled property by encroaching upon any portion of the A scheduled property. Stop. It appears that the order of injunction dated 19th April 2023 was vacated, and the injunction petition was rejected on contest by the learned court, video order dated 24th November 2023. Stop. Paragraph. As on date, there is no order from any competent court restraining Trishna Mondal from proceeding with the construction work. Stop. Next. In view of the above, the police was absolutely no. In view of the above, it was absolutely improper and illegal on the part of the police to restrain Trishna from carrying on the construction work, which Trishna claims to be made in terms of the sanction granted by the Pradhan of the Gram Panchayat.
No, my lord, that is another issue. The sanction granted by the Panchayat Samiti, who have no jurisdiction.
This is the meter.
earlier occasion, your lordship directed to consider a representation by the concerned authority. That will, up till now, my lord, the order was not passed. That can be said by the concerned authority, my lord.
Yes.
This is the next matter.
Directed your lordship observation, if your lordship will see.
How, what is the height of your building?
Super Pradhan, my lord, is the authority. Super my.
If Pradhan is the authority, how can you obtain instruction, plan sanction from the Panchayat Samiti? That you cannot do.
My junior is with the.
That I have to take instruction, but so far, your lordship, my lord, I have to take instruction regarding the height of the building and sanction. But kindly see, my lord, earlier occasion, none of the parties, your lordship hold is. None of the parties has been able to put the order of committee for directing the police to it. Order to.
No, but the thing is, if you are raising construction without a proper sanction plan, how can you do it?
Well, that your lordship has not been decided by any authority yet. I am doing the illegal construction.
Yes. And in the meantime, you'll go on. You show me your plan.
But then kindly, my lord, give some 1 day time. I will call the client and I will show you the plan.
All right.
I have the plan earlier occasion where petition was heard. You will also kindly find from the second item. I show the sanction before your lordship. And your lordship, at that relevant point of time, the private respondent did not file a representation in the proper authority. That was observed by your lordship. Man.
It's a ground floor building, my lord.
Yes. Kindly see, my lord. Ordered 5th of December 2023 passed by your lordship. The Panchayat will not be appropriate authority to decide an adjudicate issue of the encroachment. Panchayat, however, can decide as to whether construction is being made in accordance with the sanction plan or not. In view of that, the writ petition is disposed of by directing the competent authority to cause sportive inspection and to do the same, my lord.
Which, my lord, I have already served, my lord, on the Panchayat Samiti as well as the Pradhan, the representation.
No steps have been taken, and that is the reason the contempt has been filed.
Yes,
This,
yes.
I can understand. And now, you are Choyon. Who is the contemptor, the Pradhan? What is your instruction?
Step has been taken, my lord. Already complies for the order, my lord. Inquiry has been made.
What has been made?
Spot inquiry has been made, my lord.
Upon notice?
Upon notice, my lord.
Did the parties appear?
Yes, my lord. Hearing also, in the hearing also appeared, my lord.
Then, final order?
Pass, my lord, kindly 2 weeks time, my lord. In the meantime, I will pass order.
February 23, the order was passed. We are in January 25. Time was given for 12 weeks, possibly? Yes.
Kindly give me 2 weeks time, my lord. In the meantime, I will pass order, my lord.
আচ্ছা, এটা হচ্ছে রিট পিটিশন গেল WPA 3305
But kindly don't record this.
ঠিক আছে, নেক্সট। আচ্ছা, 3305 24 দুটো একসাথে উইথ করে হচ্ছে। হ্যাঁ, আচ্ছা, এবার কন্টেম্পটা আপনি লিখুন তো। সিপ্যান, learned advocate representing the Pradhan. Did you file your wakalatnama?
In the department, I have filed.
You have? Please check, Shailesh, whether wakalatnama has been filed. Acha. Representing the Pradhan submits upon instruction that the spot inquiry and hearing has already taken place. Final order will be passed by the Pradhan shortly. So, prayer has been made to adjourn the contempt application for a period of 2 weeks. Achha. Next. In view of such submission, the contempt application, CPAN and the writ petition, WPA 3305, both stands adjourned till 13th of February.
Well, one thing, my lord, subject to lordship, kind correction.
1 minute. 13th of February, a report. Affidavit of compliance shall be filed by the Pradhan on the adjourned date with advance copy to the learned advocates representing the respective parties. Stop. Yes.
Well, one thing, subject to lordship kind corrections, my lord. Till now, my lord, no authority has declared my construction as illegal. So, my lord, under which authority police stalled the construction, my lord?
No,
Why
the police-
IC Sakrail? What?
I have mentioned that
IC Sakrail, my lord, it is their admission on earlier report. Kindly take time to look at one.
I have mentioned it was improper, it was illegal to stop the construction. This has been recorded in the order.
Good.
Right? But whether the construction is proper or not, this will depend upon the report of the Pradhan.
But my lord, subject to correction, only one thing.
The matter will appear.
My lord, only one thing, my lord. On the in this order, lordship permitted the writ petitioner to raise the construction as per the sanction plan of the Panchayat Samiti.
The court has not granted any permission. The court has only recorded that stopping was impermissible.
Absolutely, my lord. I do bound down, my lord.
The court is not permitting anybody to make any construction. এই রিপোর্ট কি বলছে ওয়াকালাতনামা ফাইল প্রধান ঠিক আছে হোয়াট ইজ দিস এইটার একটা এফিডেভিট সার্ভিস আছে সি প্যানেটটা রেখে দেবেন মান্থলি লিস্ট 2:30 বাজে হ্যাঁ ঠিক আছে
Mr. Swarkar is leading the petitioners, my lord. He is indisposed, my lord, today, my lord. A short accommodation, my lord, may be granted.
Short means how short?
My lord, 1 week's time, my lord.
My lord, I have taken out a CAN
I
application
also filed a CAN application
for addition of
My
party in
lord,
this
I am
proceeding.
for addition of party.
Respondent lordship, purely civil dispute, allegation made against the private respondents, although they have not been made party herein. The private respondent filed a writ petition, then mail file a report. There is an indication in the report lordship.
So we have filed
earlier report 10342 that was disposed of.
In my CAN, I have disclosed the orders passed by your lordship in this.
They have not been made party.
Yes, your lordship. Your lordship, in my CAN, I have annexed the orders passed by your lordship. In
Civil dispute, land-related issue lordship, allegation against
Your
the
lordship.
private respondent.
Hey, please come.
Your lordship, the writ
An
petitioner
accommodation
on the
has been
10th of
sought
the order.
for by the learned counsel representing the petitioners. Friday, I'll keep it.
Friday.
Uh,
Not Friday.
Friday.
2 applications seeking addition of party
So CAN 1 and CAN 2 both.
have been filed. Stop. Report filed by the
Trying to see the second page. Over the issue.
Inspector of Police and IC Lilwa PS. Signed on 8th January 2025. We written with the records. List on 31st.
Let a copy, my lord. Can I get a
Not related to art.
Let the
application, let the application copy be served upon us, Lord.
I shall.
Serve.
I shall.
Upon the petitioner also.
I shall.
Both.
Yes. When in course of student.
Next matter, 1 minute.
Yes, combined list.
Next matter. 1 minute.
Item 14, my lord.
1 minute.
1
Only,
minute.
yes, yes.
Why? It can
My
be
lord, because
disposed
there
of.
is a report to be called, there is a mistake in the DM's order, that a fresh order to be passed for correction of that order, because the DM has become functus officio under section 14 of the SURFACE Act. They have passed the order. There was a loan of 15 lakhs and it has been mentioned in the order 2 crores something. So it has been admitted by the bank.
देखिए इसकी आगे देखिए 14. Let me see.
Page 31 is the impugned order, my lord.
It is a typographical error. In place of 18 lakhs odd, it has become something crore. But we have already written to the DM to correct that typographical error.
Let the DM pass a fresh order, because there is a serial under the schedule of property. Page 31.
Page 31 is the order of the DM. Or it has become something.
Please come.
And serial number 3, there is a mistake in the date also. The SURFACE notice is of 7th of July 21 and it has been mentioned as 18th of January 23.
But then this has to come from the state respondents.
we are the applicant, section 14 applicant. My lord,
Y'all made wrong, indicated wrong figures.
my application was correct.
Proper, the
but
DM.
DM.
Then the state council's presence is required, don't you think?
It is by application.
Call the learned advocate for the state. Who is appearing? Go. Call him. I'm keeping it.
My lord.
Today only it can be disposed of.
Yes,
Let
yes,
him
ma'am.
come.
I'll take up 15 or the combined.
No, not 15, please. Yes.
My lord, I am for the bank, my lord. Petitioner is off.
226, you are for the bank?
Yes, my lord.
Petitioner is not here.
My lord, unfortunately not. Unfortunately, he is not here.
Has the issue been resolved?
My lord, there is no issue as such. My lord, he is the defaulter, and bank is following all the procedure to recover the dues. And my lord, he is challenging.
Has the recovery been made?
Yeah, not actually. Bank is about to sell the property, and sale notice has been issued, and everything was settled. But unfortunately, a prospective seller, someone has of his family has died. So on that day, sale could not be proceeded. My lord, next day it will be done.
Dismissed. Record appearance of the bank.
Much obliged. My lord, he is appearing for the state also.
Please record appearances.
Much obliged.
Dismissed.
I'm for the bank, my lord.
Record appearance dismissed. Your wakalatnama has been filed? Please ensure that the wakalatnama is in place. Otherwise, it will be difficult.
Lordship, in this matter, Mr. Abhishek Banerjee appearing on behalf of the respondent bank.
Where is he?
He could not attend court due to his bad health, Lordship.
Then your name will be recorded.
For the petitioner bank.
Yes, please.
The petition is agreed because of non-disposal of section 14 application.
When was it filed?
Lordship, it was filed on 24th of November 2020.
Show me your service, please.
Yes. একটু জজ চেক করে দেবেন। Should kindly come to the last annexure at page number 17 of your Lordship's brief. It was received on 24th of November 2023.
Can the DM proceed?
Yes.
Yes.
Because this is the application of section 14 of the Surface Act.
There is a time limit within which steps
Yes,
is to be
because of
taken.
non-disposal, I have come before your Lordship.
I can understand you've come. What is the time limit within which action is to be
Within
taken?
1 month, and that can be extended for another 1 month. For such extension, reasons are recorded to be in
Maximum
writing.
60 days.
Yes.
Now it is more than a year it is pending.
Yes, Lordship. This is why I have come to your Lordship for direction upon the concerned district magistrate. Because there is a statutory provision that has not been complied with. And more than because of non-disposal of section 14 application, recovery of public money has been stalled.
Actually, the bank's application under section 14 of the Surface Act is pending disposal at the end of the district magistrate, North 24 Parganas. Stop. None represents the respondent authorities.
Despite service, Lordship.
Despite service, affidavit of service taken on record. The instant writ petition is disposed of by directing the district magistrate, North 24 Parganas, to take steps in response to the application made by the bank under section 14 of the Surface Act at the earliest but positively within a period of 4 weeks from the date of communication of this order. Writ petition disposed.
Grateful, Lordship.
Lordship, I am appearing on behalf of the petitioner, Lordship.
Yes.
Lordship, in this matter, petitioner took loan from the SBI Bank in the year 2016. Before COVID, he till period of EMI was given by him. By after COVID, there is some problem. That's why he did not pay his EMI. For that reason, SURFACE proceeding was initiated. Thereafter, Lordship possession letter was issued. Everything, and the bank filed a money suit before the lower court. This is not this matter was pending before the lower court. Problem is this, Lordship, the possession was locked by the bank authority, but my meter and some essential machineries are there. I want to shift the meter and some machineries I want. For that reason, I made a representation before the bank, but they did not take any step.
The property has not been sold as yet?
No, Lordship, because money suit is pending before the lower court.
So why don't you approach the lower court to get the necessary order? You can take an order from that court where the matter is pending. Why here? Where is the representation?
Lordship, kindly come to page
56?
56, Lordship.
Taking over a physical possession, it means that all the
I
articles.
want to shift my electricity meter. This is the essential, because the person come to reading the meter, but they due to lock the property, they did not reading the meter. That's the difficult thing. I want to shift the meter, nothing else. And some valuable machineries are there.
Show me your proceeding before the learned court below.
Lordship, kindly come to page 46.
Please come. The property of the petitioner is mortgaged with the State Bank of India. Stop. The loan account has been treated as NPA. Stop. For recovery of the loan amount, the bank has initiated a money suit, which is pending consideration before the learned civil judge within brackets senior division at Barasat, being money suit number 208 of 2023. Stop. Paragraph. The petitioner submits that the bank has already taken possession of the property and has put the same under lock and key. Stop. The petitioner intends to under lock and key. Stop. The petitioner submits that there are certain valuable machineries, the electric meter and other documents inside the suit property. Stop. A prayer was made before the authorized officer of the bank requesting return of the machineries and other relief. Stop. The said representation is pending consideration. Paragraph none represents the respondents. Affidavit of service is taken on record. Stop. As it appears that a money suit is pending adjudication before the learned civil judge in respect of the self-same mortgage property. Accordingly, the instant writ petition is disposed of by observing that it will be open for the petitioner to approach the learned court where the money suit is pending for necessary relief. Stop. In the event a prayer is made before the learned court in scene of the matter, comma, then the learned court shall endeavor to dispose of the prayer of the petitioner at the earliest, but positively within a period of 8 weeks from the date of filing the petition by the petitioner. Writ petition disposed. Service. Yes. State has come. Any instruction? No. There is a mistake from the end of the district magistrate.
In the pertaining to the figure, which my learned friend has told.
Figure.
Yes. If the mistake in the figure, then he should be given the liberty to take corrective action.
Please come.
My lord, let a fresh order be passed, my lord, because this order has to be set aside.
The petitioner challenged the order of the district magistrate, North 24 Parganas, dated 13th April 2024. Under Section 14 of the SURFACE Act, filed by the bank. Stop. It appears that the dues as mentioned by the bank is approximately rupees 17 lakh and odd. Stop. The order passed by the district magistrate mentions the figure as more than rupees 2 crore. Stop. Paragraph. Learned advocate representing the bank asserts that the figure indicated in the order of the district magistrate, impugned order of the district magistrate, is incorrect. Stop. Paragraph.
As well as the SURFACE notice date also, 13/2. Serial number 3.
The above, the order passed by the district magistrate cannot be sustained and the same is accordingly set aside. Stop. The district magistrate shall take necessary corrective steps in the matter in accordance with law at the earliest. Disposed.
Grateful.
Instruction forwarded by the senior branch manager of the
Bank of Baroda.
Bank of Baroda, Vidhan Sharoni branch, dated 20th January 2025, be written with the records. Disposed.
Grateful.
Lordship, I'm praying apology not to be appeared in time.
Had you been there, it
Yes,
could have been disposed of then and there.
On the first day itself. On the earlier day itself.
Yes, 232.
If I appear for the respondents in this matter, the petition is infructuous, Your Lordship, because they have challenged a sale notice dated 30th August 2024.
Before DRT?
Instead of DRT, they have come directly to the High Court.
Whatever, it's under challenge.
Lordship, the sale notice and the date of sale has already passed. The date of sale was 21st September. There were no bidders. So the sale has also
The
failed.
petitioner has also lost interest
The
because you are
petitioner
not
has also
able to get hold of bidders.
Lordship.
It's none dismissed for default. Record the appearance of the bank. It has been submitted that the writ petition has become infructuous because of the subsequent steps taken by the bank to put up the secured asset for sale. Next.
Obliged, Your Lordship.
May it please, Your Lordship.
I appear for the respondent bank.
My affidavit of service is kept to the record. The present cause of action before Your Lordship is that the non-compliance of the security interest rules of Rule 88, that when a bank is going to sell a property of the borrower by way of private treaty, then there must be an agreement. And these rules are mandatory in nature.
Are you challenging any order of the DRT?
Order of the DRT.
Are you challenging?
I am challenging the order of the DRT.
Why before this
writ
court?
Because there is no other efficacious remedy. Because if the only remedy under the statute is to prefer an appeal before the DRT.
Yes.
And here the jurisdiction point I have raised, the non-compliance of the rules of this of the security interest rules, whereby I am in such a position that I have to pay the court fees of not less than 10 lakhs of rupees for no fault of mine. These are the grounds for which writ court has ample jurisdiction to look into the matter. And
Show
this
me
is
some precedent that because of the amount of court fees that you are required to pay at the time of filing the appeal, you can approach the writ court for relief.
yes, that is not an efficacious and that is not the equitable remedy for the borrower.
Then you challenge the provision of the act.
I have challenged that they have not followed the procedure of the rules of the security interest rules, because of the up to Supreme Court and our High Court also in a writ jurisdiction, it has been held that these rules are mandatory in nature, and the non-violence of the rules amounts to the setting aside of the sale process. May I indicate only this much? Thereafter, if I am not, I cannot satisfy your lordship, then in that case, I'll kindly see the security interest enforcement rules of 2022. Kindly take up Rule 8 once.
Yes.
Sale of security interest.
Yes.
Secured asset. Kindly see sub rule 5. These are the has got it. Sub rule 5. A, B, C, D. These are the 4 modes by which the property of the borrower can be sold. D is by private treaty. Has got it.
Yes.
Now, kindly come to then Rule 8. Sale by any methods other than public auction or public tender shall be on such terms as may be settled between the secured creditor and the proposed purchaser in writing. The purpose of these particular rules that has been incorporated, will see that only in 2016 itself, November 2016. The purpose of incorporating is to see that the borrower whose property was there, he can get the maximum benefit of the sale proceeds. Because the public auction is the only remedy that was available initially. And subsequently, since the bank was facing immense financial difficulty in holding the property, then the statute thought it fit to allow the bank to sell the property by private treaty. But at the same time, the statute took care of the position that the borrower should not be deprived of the situation. But these has been held by our High Court in a judgment reported in Shilabati Hospital case. Here, kindly see, আমার কাছে একটাই আছে, একটা কপি ফেলতে দেন এটা আছে কোন অসুবিধা নেই সাইটেশনটা বলে দিন citation this is reported in kindly আপনি নিয়ে আমি নিয়ে নেব Shilabati Hospital case. My lord, kindly see here, my lord, it has been held paragraph 9, bank is an authority under article 12 without jurisdiction. If it is found that if it is without jurisdiction, it can assail under Article 226 of the Constitution of India, the Decree 2010, such and such. The sale was set aside. Before that, paragraph 8, Rule 8.8 of the security interest rules requires the bank to enter into an agreement in writing with the parties affected by the property concerned. To allow the bank to sell such property other than by means of public auction. In the facts of the present case, the bank was required to take written consent not only by the borrower but also of the guarantor and the person claiming title over the property to sell such property by method other than public auction. The bank did not do so. Therefore, the bank did not adhere to the provisions of Rule 8.8 of the security interest rules. The action of the bank is therefore wholly without jurisdiction. This was also been reiterated by the Supreme Court in a judgment reported in J. Rajiv Subramaniam. It is reported in 2014.
You are the borrower.
I am the borrower.
Yes.
The cold storage and I am the borrower.
Right. You are unable to pay your dues. Now the
My
bank is holding a sale.
Sale. I cannot join any issue had it been a public auction. It has
Yes.
it did it. I'll placing the documents later on, my lord. Let me satisfy on the point of law. The bank, what bank did? Bank chose the option of selling the property by a private TT.
Yes.
And if he does so, then he has to adhere to the rules of the 2002 rules, security enforcement.
8.
Sub rule 8.
Sale by any means other than the public auction shall be on such terms as may be settled between the secured creditors and the proposed purchaser in writing. You are nowhere there.
Their right has now been legislated out, my lord. Prior to amendment,
1 minute.
By the secured creditor
and the proposed purchaser in writing. Where is the borrower? Borrower is not there.
My lord, the judgment I have cited, my lord. Well, kindly see the paragraph number 2. The learned advocate of the petitioner submits that a secured asset of the petitioner being an immovable property was sold by the bank without recoursing of public auction.
The rule that you read out,
yes, my lord,
does not require an opportunity of hearing. Does not require any notice to be given
my
to
lord.
the borrower.
That rule has been interpreted by our High Court that the person, the borrower.
Where it has been interpreted?
My lord, kindly see the judgment I have cited, my lord, paragraph 2, my lord.
Listen, the law specifically says between the secured creditors, that is the bank,
yes, my
and the proposed purchaser.
My lord.
Where are you? You are nowhere in between.
My lord, it has been, my lord, I have, my lord, kindly see the judgment, it has been interpreted in such a way by the Supreme Court also. Interpreted by the Supreme Court also in a judgment report in 2014, 5 SCC, page 651.
How can it be 2014? This came into effect only on 2016.
They are also, my lord, it was, no, my lord. Yes, 2014. This judgment is of 2014 and this has been incorporated in 2016. But here also the position of the borrower under
that was a different position.
That, my lord, that time the incorporation has not been done in 2016. But even then, the Supreme Court has, in unequivocal terms, has stated that the interests of the borrower should also be looked into in case of private treaty.
Thereafter, the legislatures, they have.
My lord, may I come back tomorrow? Let me take my chance because my lord.
What chance will you
my
take?
Lord, this has been interpreted by our High Court. My lord, this judgment was of 2018. The judgment of coordinate bench is of December 2018.
Did the judgment, did the decision take note of this expression that is used over there?
The expression, my lord, it is, my lord, expression.
It's not there. I don't see.
Between the parties in writing.
Between the parties, that means the court was not made aware of the amendment which came into effect in
Let
2016.
me come back, my lord. At least one day I am beseeching your lordship. May I come back? My
What has happened? Sale took place?
Sale took
It's
place, my
become
lord.
infructuous. I'll indicate, my lord. I'll indicate.
No, sale took place?
Sale has
Sale took
taken
place.
place. Sale
Sale
has
took
taken
place.
place 27th of August 2024.
All
There's an
right.
agreement in writing, my lord. There's a deed of conveyance that has been executed. Sale certificate has obviously been executed. Now the parties, the property has also been conveyed, including the physical possession. If my learned friend wants a copy of the deed of sale, I am ready and willing to hand it over. But that's not the
How
problem.
much money did the property fetch? Is there anything?
6.9 crores, my lord.
What was the due? Anything that you are holding over and
Lord,
above the sale price to be returned to the petitioner?
I have
What
an document where the market price showing it is more than 8 crores.
My lord, kindly, my lord, there's an unfair, before I state that, my lord, there's an instructions I have. Before that, my lord, there's an unfair statement that is made. First of all, there is no order of DRT. I'll indicate why. Number one is there is a section 14 order according to which the physical possession of the property has been taken. There were 5 attempts that were made by the bank to dispose of the property by way of a public auction. The bank could not fetch any purchasers. Once all those 5 auction attempts had failed, then the bank comes out by notice for by conveyance by way of a private treaty. That notice is the only subject matter of challenge before the writ court. Now, what the petitioners have done is they had filed a SARFACI application. They have pleaded that. Very well. I will not make submissions. Lordship will kindly look at the pleadings in their writ
Notice is
petition.
not under challenge,
They
my lord.
challenged that.
My last annexure
That's
shows, my
pleading.
lord.
They challenged that before the
Annexure
DRT.
P9, annexure
And
P9.
they challenged that by way of an interlocutory application.
Yes.
Challenged the notice. They're unable to get an order of stay in that. Without preferring an appeal from that order or going back, they don't say what happens post that in the DRT proceeding. They simultaneously come by way of a writ application. Lordship will take up page number 10.
I'll join.
Lordship will kindly take up
My
page number
document is
10.
otherwise. My document is
Lordship,
otherwise.
their writ petition.
You were not able to satisfy the court.
Lordship takes up page number 10
Page
once, my lord.
68, my lord, I put it in before the DRT by saying that they are going to, the DRT did not pass any order on the point that since the sale took place, that was the statement of
Well,
the
they
bank.
should have
May
gone
I
before
come back
the-
once, my lord?
They should have gone before the civil divisional
My
court
lord,
for
may I come
expeditious
back because,
disposal
my
of
lord,
this.
this is a property of
Civil division, DRAT, there are separate
There are remedies that they
forum.
have.
Why before the writ court?
my lord, before there is a precedence, well, when it is a efficacious remedy before the
Now
226.
the law that you are relying upon is not in your favor.
In
the
fact,
law
Justice
is what it is.
Boshak's order is also distinguishable. That says that the matter had been pending for 10 years or 15 years in that. In this case, my lord, the
Yes,
sale has happened
this
last
is also,
year.
this is also, my lord, may I come back, my lord, may I come back, my lord, to show, my lord, the judgment in favor, my favor, that the writ court has ample power in case of for
dismiss this,
efficacious
my lord.
remedy.
I don't have a
Only
difficulty
one
if they are
chance I am beseeching, my lord.
my
Only
lord, they
one
might
chance
be-
I am
they
beseeching.
could be granted
My lord will
liberty to
dismiss it on the
pursue their
next day, my lord. If possible, he'll dismiss it on the next day. Only one day I'll travel my learned friend, my lord. Only another day, my lord, matter of
There's a
5 days,
section
my
17
Only not
pending.
today will do. No, it will not
will
will
not
not to his benefit. It cannot.
lord. Only one day I am
this is
beseeching
the-
your lordship, my lord. One day, my lord.
The petitioner the petitioner is aggrieved by the action taken by the debts Kolkata Debts Recovery Tribunal number 2.
One moment. My lord looks at the order. They are not challenging any DRT order. They're only challenging the notice for sale by private treaty. They haven't assailed any order passed by the DRT in this writ petition. Lordship looks at prayer C and prayer A. This is a notice that the bank has issued.
It is our
And they have
specific case,
they
my
have
lord.
challenged it before the DRT. Their case is not that they are challenging an order passed by the DRT.
It is our-
Their alternative remedy is not the DRAT. Their alternative remedy is the DRT.
My lord, kindly
And
see.
they have
page
already
10,
invoked the jurisdiction.
Page 10, page 10, subparagraph W, I have specifically stated, my lord. It is the impugned order. 10th of September 2014, my lord.
The writ petition arises out of the proceedings taken by the bank to recover the dues under the SARFACI Act 2002. Stop paragraph. Learned advocate representing the petitioner seeks time to get prepared on the issue with regard to the maintainability of the writ petition. Stop. When?
2 days, my lord, 2 days, my lord, accommodation.
31st. List on 31st, Friday. Service is taken on record.
I'm grateful.
2004, right? Lordship, I'm appearing for the finance
I'm
company.
appealing for the petitioners, my lord.
You are for the
Finance
bank?
company. Finance company.
Finance
My
company.
lord, my affidavit of service.
Aye,
My lord, the petitioners before your lordship, they are neither borrower nor the guarantor, my lord. Petitioner number 1 has purchased the flat from petitioner number 2. Petitioner number 2 is a promoter who has developed the subject premises, my lord, and out of the developer's allocation, he has sold the flat to petitioner number 1 in the year 2019, my lord. Petitioner number 1 never went to any bank or mortgage, nothing, my lord. With his personal money, my lord, he has purchased the property. Now, my lord, in 2023, my lord, suddenly I saw a section 14 notice has been pasted and the padlock has been put down in my flat, my lord. I was surprised, my lord. I pulled out certified copy. I came to know, my lord, someone has forged the signature of petitioner number 2, got a deed registered in respect of a flat which description says, my lord, it does not it is not there, my lord, in the same premises, my lord, in the second floor, my lord. The flat is not existent, my lord. Based on that, they have issued 13-2 notice, 13-4 notice. I have pulled out from the certified copy, my lord. Loan was taken over by someone else, my lord. Obviously, 13-2, 13-4 has been sent to them, my lord. I have never received any 13-2, 13-4 notice, my lord. Suddenly, a section 14 proceeding has been initiated. May I just show the deed, my lord, first, by which I have purchased the flat? If my lord kindly comes to page number 32, my lord.
But then how is the writ petition maintainable?
Absolutely not.
My lord, I have never received any 13-2, 13-4. Even if I want to go to DRT, my lord, I cannot, because the limitation period has gone, my lord. Section 14 they have sent right now, my lord.
So you have to make out a case in that way.
Yes,
How will the writ be maintainable against this IIFL Home Finance?
My lord, kindly sees, my lord, they are non-banking financial corporation guided by the provisions of RBI, my lord.
They be guided. They are not statutory
under
authorities.
SARFAESI also, my lord.
They are not statutory authorities.
My lord,
Cannot be treated as Article 12.
kindly sees the fraud played upon
No,
me, my
fraud
lord.
played, you approach the tribunal.
My lord, kindly sees, my lord. First, you
Nothing
kindly
doing.
sees the deed, my lord, for once.
Have you been able to recover the money?
I have
As of
not
now,
taken loan.
Sale has not been conducted, your lordship. Sale has not been conducted.
Sale as you have the documents.
I have to, lordship. I'm only on the maintainability ground. I have to see on whatever the documents are.
That flat does not exist, my lord. They have put the padlock on my premises.
Whatever it is, they have to approach the
person
DRT in
are
accordance
involved,
with
my
the
lord.
They have to approach the DRT in accordance with it.
They will approach wherever they feel like. But under which authority of law did you put a padlock over their property?
No, as per section 14, not your lordship.
Section 14?
Yes, yes.
Where is the property? You have the documents of the property?
As per the deed, we have.
Where is the deed?
The deed is annexed itself.
Deed I have annexed, my lord. I what the fake deed I have pulled out. I'll show
They
3
have
photographs.
only contended the signature is forged. But how am I?
They should have done their due diligence, my lord.
Not only the signature, according to the petitioner, the flat does not exist at all.
Does not exist, my lord.
Where is the flat? Is there a existence of the flat? Will your client be able to recover the due
I have to get
from somebody else?
I have to get instruction. If there's no existence of the flat itself, I have to get instructions on it. But I'm only on the maintainability ground, your lordship.
The writ petition will be dismissed as non-maintainable. But at the same time,
yes,
how will you recover the dues?
Lordship, I understand what is called. But your lordship, I have to get instruction. I have no instruction as of now, your lordship.
Did you file your wakalatnama?
Yes, that I have filed.
You have? Please check whether the wakalatnama is there or not. Did you file any complaint before the police?
I filed complaint before the police, my lord.
You proceed with that.
I will do that, my lord.
Also-
But petitioner number 1 kindly considers the fate of the petitioner number 1.
Anything
My lord,
against
he has done
any
nothing, my
person
lord.
that it will not be maintainable.
He
Please
has
come.
done nothing, my lord. Kindly considers. Then, my lord, kindly. My lord, their statutory body, my lord. They are amenable to read jurisdiction, my lord.
No. How can it be?
Absolutely.
My lord, under SARFAESI Act, my lord.
The petitioner is aggrieved by the action taken by IIFL,
Finance company.
Home Finance Limited, a non-banking financial corporation. Stop. According to the petitioners, none of them obtained any loan from the finance company. Stop. The finance company has illegally and arbitrarily put a padlock over the premises of the petitioners. Petitioner number 1. Stop. Paragraph. The learned counsel representing the finance company raises an issue with regard to the maintainability of the writ petition. Stop. Paragraph. The court is of the opinion that the finance company, that is IIFL, Home Finance Limited, being a private company, cannot be treated as state under Article 12 of the Constitution of India. And the writ petition filed against such body will not be maintainable. Stop. Paragraph. In view of the above, the writ petition fails and is hereby dismissed. Stop. The dismissal of the writ petition will not stand in the way of the petitioners from approaching the competent forum for remedy if so advised. Forum in accordance with law.
If my lord kindly condones the delay, if any, my lord, for approaching the
This
DRT.
bench does not have this jurisdiction.
Keep your light.
Hey, Pradeep, Vakalatnama answer. 235.
Lordship, Mr. Abhishek Banerjee appearing behalf of the respondent bank.
Your name, please put in. Dismiss for default. হবে না। What is your name? কোথায় গেল?
পায়েল ঘোষ।
কোনটা? এটা কি রেসপন্ডেন্ট? ওইটা কতজন ছিল? এনার নাম কি? হ্যাঁ, অমর সিং, ওনার নামটাই দিন। আরেকজন ছিল, অ্যাসিস্ট করছিল, একজন ছিল, অনলি ওনার নামটাই দিয়ে দিন। হোয়াট ইজ ইয়োর নেম?
পায়েল ঘোষ।
এই এনারটা শুধু নাম দিয়ে দেবেন। ইয়েস। Dismissed. Dismiss.
Lordship, I beg to appear on the petitioner. Lordship, before your Lordship takes the matter, Lordship, as I can see that Lordship has observed that non-banking financial corporation cannot be amenable under the writ. Lordship, may I come back day after tomorrow, Lordship, because there is some judgment, Lordship, of this coordinate bench, Lordship, that the non-banking financial corporation can be also amenable under the writ jurisdiction if they are discharging any statutory liabilities or functioning under the any statutes, Lordship. Lordship, may I come back, Lordship, day after tomorrow?
Very well. Come back. When?
Lordship,
Next
day after
month?
tomorrow. No, Lordship.
Next month.
Lordship, may kindly, Lordship,
To
they
allow the learned
small matter,
advocate-
small facts, my Lordship.
আচ্ছা ঠিক আছে, to allow the learned advocate representing the petitioner to come prepared. List on Friday, 31st.
Lordship,
Let notice be served
Lordship,
upon the non-appearing
Lordship,
respondents.
Lordship, my learned senior friend is helping me, Lordship, with that judgment, Lordship, that judgment.
You read it, then come.
Lordship, I know it's because this matter, Lordship, taken up this type of matters, lots of matter has been taken in this jurisdiction, Lordship,
Yes.
previously also.
You get ready, come back on Friday.
Grateful, Lordship. Grateful.
For the petitioner, my lord.
Yes.
My lord, please keep this matter next monthly list because the service not done.
Hey, dekhi. 2024 writ petition not yet served. I will dismiss it here and now. September it was filed, and in January there is no service. Anjali Kuntu, learned advocate representing the petitioner, submits that the writ petition has not been served upon the respondents. Stop. Prayer has been made, permitting the petitioners to serve a copy of the writ petition. Stop. Paragraph. It appears that the writ petition was affirmed and filed on September, date on 26th of September 2024. Stop paragraph. The petitioners were bound to effect service to the respondents immediately thereafter. Stop. Even in January, the copy of the writ petition has not been served. Stop. The court is constrained to observe that the petitioner is not diligent to proceed with the matter and accordingly has not served the copy of the writ petition till date. Stop. The writ petition stands dismissed as not pressed.
अच्छा बोला reply होता है
I'm appearing for the petitioner lordship.
Yes.
This is my
But I'm
affidavit
for the
of
private
service. This is
respondent
my application
4
for
and 5.
speedy disposal of my pending section 14 application before the learned district magistrate, Purbo Bardhaman lordship.
When was it filed?
It was filed in May 2024 lordship.
Who are you representing?
But I have already initiated SARFAESI application before the DRT. It was filed in my lord
There is
April
no
2024. I am
there
for
is
the
no
borrower.
stay granted from the learned.
You do not have a say over here. When was the application filed?
The section 14 application was filed in July 2024, July 8, 2024 lordship.
The petitioner prays for a direction upon the district magistrate.
District magistrate Purbo Bardhaman lordship. Having the case SARFAESI case number 31 of 2024.
Purbo Bardhaman. To dispose of the application under section 14 of the SARFAESI Act, which was filed in
July 8, 2024.
28th of July 2024. Stop paragraph. And represents the state despite service. Affidavit of service is taken on record. Learned advocate, you are the borrower?
Yes, my lord. I am for the borrower.
Representing the private respondents, submits that the borrowers have preferred an application before the Debts Recovery Tribunal, which is pending.
Pending, my lord. Pending adjudication.
Next. Without entering into the merit of the application under section 14 of the SARFAESI Act, the instant writ petition is disposed of by directing the respondent number 2 to take steps in terms of the application, to take steps in accordance with law in a response to the application made by the bank under section 14 of the SARFAESI Act at the earliest, but positively within a period of 30 days from the date of communication. Disposed.
Grateful, Lordship.
What I beg to appear on behalf of the respondent bank. 241.
Petitioner is not here. Dismissed.
My lord, I am appearing on behalf of the state.
I am appearing behalf of the respondent bank lordship.
You are for the?
For the state, my lord.
Very well. Dismissed. Record appearance.
What is your beg to appear on behalf of the beg to appear on behalf of the respondent?
I appear for the petitioner in this matter. Lordship, the petitioners are the legal heirs of the deceased, who was the owner of a hotel in Raichok. Now, Lordship, the owner, she had mortgaged her property with the bank for availing the loan. Thereafter, once she passed away in the year 2023, the legal heirs of the owner, that is the petitioners herein, they have time to time, they have for 1 full year, they have deposited amounts every month. 20,000 deposits have been made every month. But the bank took a stand that you cannot be substituted in place of the deceased Shushmita Bhomik, because this is the bank's policy. That is what the bank is stating before the petitioners. So now what is happening, this is the only account from which my business is running. Now, on the one hand, I have deposited for 1 full year, 20,000. On the other hand, my business is a jeopardy because I am not being able to operate my only bank account. Now, in the situation, if the legal heirs are not allowed to be substituted in place of the deceased owner, then the business will have to be closed. Now, Your Lordship, I would take Your Lordship to page.
Any proceeding initiated under the SARFAESI Act?
No, Lordship. They have issued notices after I stopped. For 1 whole year, I have paid the amounts. Next, as soon as I stop payment, they have issued notice under 13(2). I have
Obviously, since you have stopped payment, that is the reason.
Now, Lordship, I'm not being allowed to withdraw any amount, but I am being allowed to deposit amounts. Lordship will kindly come to page 61.
After 13(2), there is 13(4) proceeding is required to be taken, and they will take steps.
I understand everything, but Lordship, if I am not allowed to run my business by substituting the names, Lordship, how am I supposed to bring in 15 lakhs and odd to just close the account and open a new account? That is the stand taken by the bank, that you have to close down this account and you have to open a new account, and from that account again you can avail a loan. If I have a running account in the name of my mother or my late wife, so why can't I operate the account if I'm the legal heir over there? Lordship comes to page 61 once.
What does the loan agreements mention with regard to the death of the borrower?
Lordship, as such, that the bank will be able to say, because we are not given all the papers at the time of entering into the, because this was in the year 2004.
Let me hear the bank.
My first submission before Your Lordship would be to Lordship, can we take able to their prayer? The prayer from B, C, D onwards, the prayer to still the process of SARFAESI action taken by the bank, whereby the bank is to 13(2) and position notice due to default being made by their predecessor who took loan and made default in repayment of the loan amount. The mortgage property is mortgage with the bank. 1. Second, despite taking due notice regarding the death of the principal borrower, admittedly the borrower was handling the account in her sole name. It is not a case it was a private limited company or it was a savings account where the legal years, the concept of legal years to be substituted. Since the sole borrower has made default, he died. So the bank always maintained a CIF, customer identification number. Upon the death of an individual account holder who took the loan, that CIF number ceased to exist. And there cannot be any transaction in that account. The bank has made a proposal to the petitioner. In their writ petition, in paragraph number 18, they categorically admitted on affidavit they are ready and willing to pay. Subject to bank will allow them to operate the account standing in the name of the deceased person. The bank informed the petitioner that, look, it is not possible for us because the since CIF has ceased to exist, there cannot be any operation. What we will do, we will transfer the liability by closing this account, opening your account, kindly submit your documents. But they are adamant to know, you have to substitute our name in that account itself. And for that, they have filed.
Can the account be closed without clearing of the entire dues?
Well, here, under the SARFAESI Act, the account has been, in the instant case, the bank has issued a SARFAESI proceeding against the legal heirs. If your principal predecessor has taken a loan, he has made default, account is NPA, you all are...
Just tell me, you want the bank account of the deceased to be closed, and what will happen to the loan? Will it be transferred to in the name of the legal?
They are ready to. Being legal here, they are under obligation to. They intend to take the liability, the bank is ready to. But not in the same account. It will be opened in her account. Where is the difficulty? But they are saying no, kindly allow us the self account.
No, Lordship. Lordship comes to page 61. Lordship comes to second paragraph of page 61. As already informed to you, the renewal was done for a period of 1 year and the limit has expired on 11/4/2024. Therefore, the account is in overdrawn status, having a debit balance of 15,15,283 plus accrued interest and penal charges, if any. Please treat this letter as a formal intimation from the bank for having recalled the account, and consequently, you are requested to surrender the account by repaying the dues of the bank, which shall include the outstanding principal, accrued interest, and any penal charges as levied as per rules of the bank. If the dues of the bank are not repaid within 11 days from the date of issue of this letter, the account will be classified as non-performing asset. On day 11, they classified my account as non-performing.
See, you give them 11 days time to clear up 15 lakh of rupees. It's impossible.
We turned up.
They
We have turned up.
Their name first.
Listen, you want the money to be back. They want their account to run so that they can earn money.
Kindly appreciate. The account is in the name of disease. How that can be allowed to be operated?
You open a different account in their name.
Ready to. They are not ready to.
Your language does not say so. Your language says you have to clear off within 11 days.
Here, Lordship, kindly appreciate your Lordship, in a case of a cash credit and overdraft, it is a credit facilities which is only available for 1 year. Every year it will be renewed. And the moment you will not renew it within time, if the account overdraft, it will automatically become termed NPA for the RBI.
Without a solution, what is to be done? I'll adjourn the matter. It is your submission that the entire liability will be transferred to them and they are willing to repay off the loan.
Yes.
Lordship, one more thing I just want to clarify. If my overdraft limit is for 24 lakhs, how can 15 lakhs? The first paragraph says that sanction to Shushmita Bhomik for a limit of 24 lakhs. If my limit is 24 lakhs, how can 15 lakhs, 15,000 be said that your account is overdraft? It's running.
No, 24 was the amount which was sanctioned. This is what is
so unless I reach the limit of 24, they cannot classify my account as
now
NPA.
the person has expired.
Now the person, but after that also we have Lordship comes to
whatever.
Annex
Please
P3
sit with
as
the,
at
please
page
sit.
44.
I am giving direction. Please come. The original account holder of the subject account, please give the number or something so that I can mention.
So the account was sanctioned in the name of Susmita Bhomik.
Acha.
The principal borrower who has
Vide account number 200-766-34203. Original account holder বললাম তো ব্র্যাকেটে লিখে দিন তো শ্রীমতী সুস্মিতা ভৌমিক পাতাটা মোড়া আছে 61 পাতা has expired. Stop. Her legal heirs intend to repay the loan amount standing in the name of their deceased predecessor in interest.
Lordship, it is not a question of repaying the account. We want to run the account.
To operate the account.
Yes, Lord.
To operate the account.
I'm grateful.
ঠিক আছে. The bank is allegedly not permitting the petitioners to operate the said account. Stop. Paragraph. Learned counsel for the petitioners draws attention of the court to a communication dated 27th of June 2024 issued by the Chief Manager of the Indian Bank, Diamond Harbour Road branch, mentioning that the account was last renewed on 24th not 24th, not 12th April 2023. And after the expiry of the borrower, it is not possible to renew the facility further. Stop. The petitioners have been requested to surrender the account by repaying the dues to the bank, including the outstanding principal, accrued interest, and any penal charges. Failing which, the charges within 11 days. Failing which, the account shall be classified as NPA, and the bank will initiate legal action for recovery of the dues. Paragraph. Learned advocate representing the petitioners submits that the legal heirs are ready and willing to pay off any due of the bank, provided the bank permits the legal heirs of the account holder to operate the bank account. Paragraph. Learned advocate representing the bank submits that on the expiry of the sole account holder, the said account cannot be permitted to be operated. Step. The liability of the deceased account holder has to be borne by the legal heirs. Legal heirs by opening a separate bank account. And there is no scope to permit the legal heirs of the deceased to operate the bank account which has become which has been closed down on account of the death of the account holder. Paragraph. It appears from the submission made on behalf of the parties that the legal heirs of the deceased borrower are interested to operate the account of their deceased predecessor in interest. Paragraph. The operation may be done by way of opening a new account, and it is not necessarily that the old account number, which was the identification number of the deceased account holder, has to be used. Stop. Paragraph. It will be open for the bank to let the petitioners know, to intimate the petitioners the formalities that are required to be complied for operating the bank account. Now, for operating the, intimating the petitioners the formalities required to control the finances, which are there in the bank account of the deceased account holder. Stop. Paragraph. The writ petition stands adjourned till 17th of February 2024. An updated report shall be placed before this court on the urgent date.
Only one indulgence. Whatever amount is lying in the account, that balance has to be transferred to the new account. So that direction should be there.
Obviously, otherwise, how will you operate?
Will kindly direct, bank will interpret in some other way, and they'll say that the Lordship has directed for opening a new account. Lordship has directed for opening a new account, but with the balance of the previous account.
Kindly also take a note. Your Lordship already recorded my submission. Only one submission. The account has also been classified as a.
That is the deliberately they classified. They deliberately classified.
In order to upgrade the account being classified as NPA, there are certain banking parameters which they are supposed to fulfill.
Lordship, if
It
they
is not a case
Lordship,
where the account
if
has
they
not been
if
Now
they,
we'll see that what is to be done.
Lordship will kindly just one line that the old amount be transferred to the new account. Lordship.
To not to repay the liability.
Lordship, I will repay my liability.
Cannot
I have
be.
been running the account since
Bound to repay the
2004.
liability.
Since 2004, I've been running my account
They
successfully.
will be bound, but you permit them to operate the bank account so that they can generate funds. Otherwise, how will they pay the money?
It has been turned NPA. NPA account cannot be allowed to operate. Lordship knows.
Whatever is to be done, please do it.
Lordship will kindly put it down in the order,
Acha.
Lordship. Otherwise, they will not comply.
ওই লাস্টের দিকে এখানে একটা বললাম না লায়াবিলিটি কি বললাম
So kindly record NPA also, so that there may not be any effect, but on the part of the
এই জায়গাটাতে বললাম
NPA has been deliberately classified, Lordship.
Petitioners.
Yes.
The formalities required to control the finances which are there in the bank account of the deceased.
To control the finances which are there in the কি বললাম
In the bank account of the deceased.
হ্যাঁ
Account holder.
It's already there. You want
Lordship,
to
if
control
I
the
am not,
finances.
Lordship, the bank will not interpret it properly because they have already issued 13.2 and 13.4, Lordship. Lordship, the bank is moving leaps and bounds, Lordship. They are not allowing me to negotiate also.
Trying to frustrate the
Lordship, I am supposed to receive an amount of rupees 15 lakhs from the ARM fund. I am just telling them to put on hold my account so that I can bring the amount from the consumer forum, and thereafter I will pay the whole.
They will pay the amount once the consumer forum adjudicated.
No, Lordship,
Hold your operation.
that is not that. Lordship, I cannot run my business. Lordship, I have to run my business, Lordship. How will I run my business if my sole account is with the Indian bank?
And we are controlling public money.
The bank will not allow me to mortgage the same property twice.
How?
The bank will not allow me to mortgage the same property twice.
Thing is, your the submission that you made when you get order from the consumer forum, then you will get the money. You never know the consumer forum will rule in your favor or not. You never know, despite the ruling, whether the money will flow into your account or not. With so many ifs and buts, how can the bank run?
That is not the case, Lordship. I want to run the account. 15 lakhs is the account balance, overdue, whatever. So why should I have to pay off my whole dues? That has been going on since 2004.
They abide by the conduct of their predecessor.
How can I bring 15 lakhs if I'm not allowed to run my hotel business?
The order, let it remain as it is. We'll see what is to be done on the next occasion.
Lordship, the next date of the order, Lordship.
Yes.
I'm grateful. Affidavit of service.
Yes.
Lordship, instead of 17, can it be any other day? On 17th, I may not be available. Any day, sir.
18th of February. 18 তারিখ করে দিন।
I'm grateful.
Obliged.
Lordship, I am for the petitioner. Yes. For the bank. Lordship, I am for the petitioner. There is verbal instruction to withdraw the matter.
Withdraw?
Yes.
Second?
We have already taken physical possession. That is why it has become infructuous. That is why the prayer. I do not know. I do not know.
Who has given you the instruction?
My senior.
Your senior. What is his name?
Shreyash Mohta. Who is the on record?
You don't know his name?
Shreyash Mohta.
No, sorry, sir. He is not the advocate on record. What is your name?
Partha Ghosh, ma'am. Lordship.
I see Aranya Shah's name over here.
After that, my senior filed Wakalatnama.
Check up whether there is new Wakalatnama or not. Dekhun to. Check up. Shreyash Mohta.
Yes, Lordship.
All right. I will place the matter in the list. 2 or 3 days later, bring a written instruction from your client so that it can be kept on record.
Okay.
Followed?
Okay, Lordship.
Please come. Learned advocate. Put your name over here, not the name of the advocate on record. Learned advocate for the petitioner submits that there is verbal instruction from the petitioner to withdraw the writ petition. Paragraph, the bank is represented and submits that physical possession of the secured asset has been taken. Paragraph be that as it may, as there is a verbal instruction to withdraw, let the written instruction from the petitioner be placed on record on the adjourned date. When do I keep it? Next Monday?
Yes, Lordship.
Next Monday, oh, it's a holiday.
Yes. Lordship, next Monday is Saraswati Puja vacation.
Yes. So, next working day in the next
Lordship.
week?
Yeah. Yes, Lordship.
আপনি করুন না তো। 5 তারিখে রেখে দিন। 5th.
Yes, Lordship. Grateful.
Is my petition, Lordship. This is the service. It is praying for the necessary order from learned DM, Purbo Mednipur, against the Section 14
Section
application.
14.
The
Yes.
Section 14 application was filed in the year 2021.
21?
Yes, 2021, 5th August. And all the necessary hearing was concluded 21st July 2022 by. There are several request letter has been given to the DM, but till date the bank
DM has
unable
not
to-
taken
yes,
any steps.
yes.
Who are you? Borrower, obviously.
No, why obviously?
Otherwise, the borrower, who else will come? The bank will run after the borrower for repaying the money. There is no other reason. Yes, you are the state. DM.
But I will put a question to myself, because it is another surface side. Now, surface side, section 14, subsection 3, it says that no act of the chief metropolitan magistrate or the district magistrate or any other officer authorized by the chief metropolitan magistrate or district magistrate done in pursuance of this section shall be called in question in any court or before any authority. Now, so far as what has happened, that I need to take instructions. What the DM has done.
Without taking instruction, you are relying upon the legal provision and saying that this is not possible. Since 21, this is pending. 22, the hearing concluded. This is what the petitioner submits. And now, you say the action of the DM cannot be questioned in court.
Part of it, so far as the facts of the case, I have to take instruction. And
What were you doing from September? November?
But I think that is
October. I see it. When was it served? 8th of October.
October.
What is your submission?
Gross suppression.
All right.
First is, kindly comes to page 8, paragraph 18.
Yes.
And one by one, I show your lordship. First is this paragraph. Did not file any application before Debts Recovery Tribunal, which is in the knowledge of your petitioner. The petitioner is the bank, the authorized officer of the bank, of the stressed asset, something. He has affirmed this affidavit. Apart from that, he has disclosed that the quantification of dues is to the tune of 14 crores and odd. Now, admittedly, SA 40 of 2021 is pending and is being considered by the learned Debts Recovery Tribunal.
And the bank is represented.
Yes. The bank is not only represented, in the last IA, this is the order made by, I'm handing over a copy the this is the last IA, 16th of January 2025. The bank was represented and the IA got disposed of on the submission that they did not get a adequate borrower. So, they've already
borrower purchaser.
Purchaser. So, the property has also been put to auction. If he supposes that. Now, we have taken out adequate applications.
So what remains in the section 14 application?
Apart from that, what we have learned from your lordship, anything. I might be the very bad man, but candid facts need to be pointed out to the court.
Certainly.
Kindly see, the dues have today reduced to 5.5 crores. They know it. We have repaid 12.5 crores during this time.
Please come.
So, this writ petition, and this is the situation.
The petitioner. petitioner bank has
And
filed
they have
the
also
instant
not, this is the
petition,
last latest situation.
praying for a direction upon the district magistrate
My
to
lord,
take steps under section 14 of the SARFAESI Act. Stop.
which
In the paragraph 11, in the writ petition, there is an averment that the private respondents did not file any application before the Debts Recovery Tribunal, which is in the knowledge of the petitioner. Paragraph. Learned counsel representing the private respondent relies upon the order dated 16th of January 2025, passed by the Kolkata Debts Recovery Tribunal number 2 in SA 40/2021. Stuff. The the order records that the bank has moved for order records that sale of the secured asset was scheduled on 16th of January 2025, but as no bidder has responded, the sale notice could not be proceeded further. Stop paragraph. As it appears that the issue in question is already pending consideration before the concerned Debts Recovery Tribunal, there is no reason to exercise interference in the instant writ petition. Stop. The writ petition fails and is hereby dismissed. Stop. Dismissal of the writ petition will not stand in the way of the parties to approach the competent forum for remedy.
Another one sentence more. Please see the other document which I have handed over. Please see the next page, the second page. In the teeth of the averments made in the writ petition, kindly sees the dues today, 5.32 crores.
Very well, it has come down, you say. It's all right. This was filed in October 24.
As on October,
must have
kindly
filed.
visualize. What happens, your lordship also knows, in the DRT, because of these IAs and because of, we are compelled at times to pay the money. Pay this amount, pay, and that by due of that, we have already, paid, 12.5 crores.
Very well.
Right,
Next.
Grateful.
246. Dismissed.
For the bank.
Please record your appearance.
46, I am for petition.
246. I was looking for you. I could not find you. Degi, 246. Yes.
Evidence service time. But the impugned order annexed P4 passed by the district magistrate is under challenge, as well as the non-consideration of the representation. These are the two things I have placed before Lordship, my lord. When my representation I made, the bank says that Reserve Bank circular is not binding on them. I have stated on oath. Section 12 of the SARFAESI Act, they have exercised their power under the SARFAESI Act. And Section 12 says any direction on order passed by the RBI is a binding appeal to the bank. Section 12 people also kindly have.
Yes. Then what has happened?
That is one that has not been, they have ignored to consider. Number two, my lord, I have challenged the order of the district magistrate alleging exercise of power section 14. That was made ex parte and without giving any notice to me. The statute does not provide any opportunity of hearing. I am taken advantage of the declaration of law made by the appeals court. In the judgment reported in 3 judges bench, my lord, 1989, 1 SCC, I have also, my lord. (764) H. and Treharne's case. My lord, paragraph 7, I have ground number 7, I have said to my lord. The appeals court has declared the law. Even the act does not provide for giving any opportunity hearing. But any action without giving any opportunity is illegal, would be violating Article 14. That is paragraph 11 of the judgment, my lord. 3 judges bench, if your lordship consider that it's have some consideration, your lordship can.
Show me the order of the DM. When
Yes,
was it passed?
My lord, it was,
When was it passed?
my lord, kindly come. Kindly come, my lord, page 45. Page 45.
September 23.
Yes, my lord.
Thereafter, what happened?
It was, my lord, the back portion, your lordship, kindly page 48. It was served on 29th of January 2024.
On 29th of January 2024.
My lord. Thereafter, my lord, I have come before lordship challenging that order that it is.
And in the meantime, possession has not been taken. 1 year has elapsed. Possession taken. What remains?
Well, I have filed pending before your lordship.
Maybe pending, but in the
I
meantime,
have challenged your lordship, kindly pass that
what
order.
happened to the secured asset? Sold off?
Yes, my lord. My lord, first
Sale
thing is that-
certificate issued?
First thing is that, my lord, the surface action already pending and filed by them. My lord, kindly see. And my lord, they have already given a letter that they want to they don't want to proceed with the same.
With the?
With the same, that is surface
Same surface proceeding they do not want to proceed.
But still it is pending. My lord, then they have came to before your lordship, my lord. And the second thing is that, my lord, kindly see the prayer portion.
24 October 2024.
Page number 34, my lord, of the writ petition.
Tell me one thing, what have you done with the property?
My lord, that thing, the position has been taken.
Yes.
And we are going to sale of this property. Till now, that property has not been sold out. We are going to private treaty for the sale.
Private treaty?
Application and other things.
And the petitioner is not interested to pay off the loan.
No, I have made a prayer, my lord. I have already paid 50 lakhs.
What is
what
the
my
due?
lord is saying?
What is the due?
My lord, I do not have the agreement.
86 lakhs are not.
My lord, I have paid, my lord, I made a prayer for OTS. I have paid already 50 lakhs and not. Already paid. They have taken. But I made a prayer for OTS that has not been considered. They have kept pending. And by this time, they have taken possession of the property by taking advantage of the GM's order. My lord, I have challenged the legality and validity of the GM's order.
No, legality, validity of the DM's order is, fact remains that you have not paid off the dues. Your proceeding before the Debts Recovery Tribunal is pending.
That is not with regard to Section 14 application.
Maybe with regard to the loan account.
Maybe, my lord.
Then?
My lord, your lordship, I am not on that. I have challenged before lordship, challenge legality and validity of the GM's order. Whether it is good or bad. Whether it is legal or illegal. Without
any one-time settlement? Any one-time settlement you want to enter into with them?
After that, they have paid the first installment. After that, they have paid nothing. For that reason, my lord,
Did the settlement take place?
At present, for that reason, first installment they have paid. After
that means the settlement took place.
One settlement amount had been paid, my lord.
One installment they paid.
Paid. After that, they did not turn up.
Again failed.
Again failed. And after that, we put on sale. For that reason, my
the
lord.
client is not inclined to pay.
Money is the factor.
Money?
There is no money.
Money
is the factor. COVID, kindly allow me. Sure. COVID-19 has practically destroyed the nation.
True. Then what can be done? The bank is not writing off the
No.
loan.
Mala, it's a business.
Bank is not
it's a
writing off
cascaded
the loan.
account.
Show me the judgment that you are.
Yes,
That is before the uh,
This is discussion of law made by the apex court.
before surfacing, my lord. That is.
Law cannot be old or new. Paragraph is have a binding effect. 3 judges bench judgment.
Paragraph
11, 12, and
11. Section 11. Under which provision of law was this passed?
HL Trahan says, madam. ওইটা আসুক তারপর দিয়ে দেবে
Caltex in the undertaking of India of Caltex Act 17. Relation to the undertakings. Paragraph 11.
11, my lord.
And the notice that the alteration of the terms and conditions. How is this applicable over here?
Well, even the act does not provide for opportunity to hearing, it's the bounden duty of the authority to hear the parties and to pass an order.
No, no.
11, 12, and 13.
This is absolutely separate provision of law.
Madam,
Please come.
separate provision. Discussion of law, madam, principal law is decided. If your lordship
In the instant writ petition, the petitioners have challenged the order passed by the district magistrate.
My lord, once again, kindly give an intelligence to page number 34, my lord, once. The prayer portion. They have not prayed at all regarding that district magistrate order. Page number 33 and 34, prayer portion.
Consider and decide the representation. Transmit, produce, such and such.
interim order prayer E, my lord, if your lordship can see.
Yes, injunction restraining the
What is that?
respondents not to give any effect or further effect to the notices under section. Can this court pass such order?
P4, my lord. P4 is the DM's order.
That is the interim order.
Yes, yes.
You have not prayed for any mandamus for challenging that order. 13.2.
Here, prayer A,
Prayer A is there. Prayer A is there.
Prayer A is there.
To set aside the impugned notices,
Be careful, baby.
including the impugned order. That is there.
Yes.
কি বললাম? Dated 29th January 2024 under section 14 of the SARFAESI Act 2002. Stop. It has been submitted that the said order was passed. আচ্ছা তার আগে লিখুন the petitioner is the borrower of a loan and on account of non-payment of the loan account, loan amount, the account of the petitioner has been termed as NPA. Stop. The bank has taken steps under the SARFAESI Act. Stop. Paragraph. The petitioner submits that as no opportunity was given to the petitioner prior to disposal of the application under section 14 of the SARFAESI Act, there has been violation of the principle of natural justice. Stop. Prayer has been made to set aside the said order. Stop. In support of such submission, Learned counsel for the petitioner relies on the judgment delivered by a three-judge bench of the Honorable Supreme Court in H.L. Tehran, Trehan, Trehan, and others, versus Union of India and others, reported in 1989, 1 SCC 764. Paragraphs 11, 12, and 13. Achha, next. Learned advocate representing the bank submits that the petitioners have already approached the Debts Recovery Tribunal for relief. The application made by the petitioner before the tribunal is pending consideration. Paragraph. The learned advocate for the bank produces a copy of the letter dated 9th May 2024, filed by the petitioner before the bank, intimating his decision to withdraw the application filed before the Debts Recovery Tribunal. Stop. In the letter, it has been mentioned that the petitioner, after careful consideration and review of the circumstance, have concluded that pursuing legal action is not the appropriate course of action. And he disclosed his intention to withdraw the case before the tribunal. Stop. The case number is also mentioned in the said letter. Stop. Paragraph. The petition filed by the petitioner before the tribunal has also been produced before this court. Stop. Paragraph. The said application made by the petitioner is, however, pending consideration despite the communication made by the petitioner to the bank disclosing his intention to withdraw the same. Achha, next. The on a perusal of the provisions of Section 14 of the SARFAESI Act, it appears that there is no scope for granting any opportunity of hearing to the aggrieved party. Stop. The provision mentions that on a request being made by the secured creditor to take over possession of the secured asset, comma, the district magistrate may take steps in accordance with the said provision. Stop. Paragraph. The district magistrate has acted accordingly. Stop. The Petitioner has already approached the forum, the competent forum for relief. Stop paragraph. In view of the above, there is no scope for interference in the instant writ petition. Stop. The writ petition fails and is hereby dismissed.
Section 14, your lordship is the only, the High Court is the only forum. Section 14.
Forum.
Section 14 challenge, only, this is the only forum.
Lord, item 247, my lord, I beg to appear on behalf of the petitioner. Lord, may I file the affidavit of service, my lord? Both the respondents have been served in this matter.
Yes.
Yes. My lord, the facts in this case is, my lord, the petitioner is an aggrieved person in the sense, my lord, that the petitioner is an auction purchaser of a property, my lord, which was auctioned in the year 2022. My lord, the advertisement for the auction, my lord, clearly stated, my lord, that there is no impediment or fetter in the said property, my lord. Based on the advertisement, we participated in the auction and we were being declared as the highest bidder. My lord, we have, in pursuant to, my lord, declaration of the highest bidder, my lord, I put in the entire money, the sale consideration of 2.83 crores, my lord. Now, thereafter, there was a confirmation which was, my lord, given in my favor. 3 months thereafter, my lord, no communication from the bank whatsoever. My lord, I write a letter to the bank stating that I have already deposited the entire consideration. Kindly issue the sale certificate in my favor. After 3 months, I come to know there was an intimation that there's already a litigation which is subsisting in respect of the said property. There's an order of injunction that has been passed by the Honorable DRT. So we cannot at this stage issue the sale certificate in your favor. My lord, thereafter, there was series of correspondence which, my lord, the petitioner, my lord, had exchanged with the bank. Finally, my lord, it's on the year 8th of August 2024, my lord, which is P13 in my writ petition. At page 41, my lord, I have inadvertently not annexed that particular, my lord, that particular communication I've omitted, but I have a copy of the, my lord, the communication from the bank. If I may just place it before your lordship. Lord, in this is a communication from Union Bank of India on 8th of August 2024, my lord, which was P13 to my writ petition, wherein last paragraph they admit and say that you have sought refund for the sale consideration. The bank has approved your request. You are requested to confirm the same by sending a scanned copy of the cancelled check in your account. My lord, in compliance, we do that. My lord, we write a letter to them, my lord, immediately. My lord, after 11 days, which is at, my lord, page 42 of my petition, I send a scanned copy of my check and I write the detailed letter, my lord, till date. My lord, unfortunately, my lord, despite me putting in this entire consideration for
Refund
a period,
has not
the
been made
refund
to
is
you.
not yet, my lord, complied with, and I have contended before the bank that not only is the refund I'm entitled to, I'm also entitled to along with interest, my lord. In support of that, my lord, I had also put on record a judgment of the Honorable Supreme Court of 2024 SCC Online SC 559, my lord, where this similar issue arose, and where, my lord, observing the high-handedness and the arbitrariness on the bank of part of the bank, my lord, the Honorable Apex, my lord, Honorable Supreme Court was also, my lord, pleased to direct the bank to refund the money along with interest. My
Where is the office of the bank?
lord, it's at Ezra Street. If your lordship sees the cost title, which is page 1 of my petition.
Please come. None appears on behalf of the respondents. Despite service, affidavit of service is taken on record. Stop. Leave granted to the petitioner to file supplementary affidavit annexing the communication of the bank dated 28th of September 2024.
But this is 8th of August 2000.
Oh, it's 8th August 2024. Stop. Let the supplementary affidavit be prepared and served upon the respondents. Can you do it by this week?
By this week, we'll comply, my lord, because there is some urgency also because of this
Yes.
matter lying there.
By 2 days, can you do it? 3 days?
Within 3 days, my lord, will come.
By 30th. Hmm. Let the respondents be put on notice that the instant writ petition will appear for consideration on 12th of February 2025. Stop. The respondents ought to be represented before this court on the adjourned date. Put it up for orders. Yes, call the next one.
Appear for respondent number 3 and 4.
We will give you appearance. Dismissed. Dismissed. Dismissed.
Your Lord, I'm appearing in item 249. I'm appearing on behalf of respondent number 3 and 4, Your Lordship.
Record appearance of respondent numbers 3 and 4, 249. Yes, 250.
Oblige, Your Lordship.
Malad, this is my application. Malad,
For the bank fund.
Malad, a very simple contention, my lord. SARFAESI Act is not applicable in my case. My lord, why I am saying so? My lord, kindly takes up, I will show only one provision and 2 circulars. My lord, kindly takes up 31A.
Who are you?
I am the borrower.
All right.
I am the borrower. My lord, SARFAESI Act is not applicable in my case.
Why?
Why, my lord? Why I am saying so? My lord, section 31A, power to exempt a class or classes of banks or financial institutions. The central government may by notification in the public interest direct that any of the provisions of this act shall not apply to such class or classes of banks or financial institutions, or shall apply to the class or classes of banks or financial institutions with such exemptions, modifications, adaptations as may be specified in the notification. My lord, this much is sufficient. My lord, this is the notification which has been issued by the Ministry of Finance, Department of Financial Services. My lord, I'm reading it. In exercise of the powers conferred under subclause 4 of clause M of subsection 1 of section 2 read with section 31A. My lord, this is 31A of the Securitization Act, the central government hereby specifies the following non-banking financial companies which are covered under clause F of section 45I of the Reserve Bank of India Act and registered with the Reserve Bank of India having asset of 500 crore rupees and above as per their last audited balance sheet as financial institutions, and hereby directs in public interest that all provisions of the said act shall apply to such financial institutions with the exception that the provisions of section 13 to 19 shall apply only to such security interest which is obtained for securing repayment of secured debt with principal amount of rupees 1 crore and above.
What is your amount?
My amount, my lord. My lord kindly takes up the DM order. My lord, it's at page 37. Kindly takes up the DM order. It's page 30. It starts from page 36, my lord. The portion, my lord, on top.
Yes.
My lord, my mentioned amount is 17 lakhs 68,000 and odd.
Page 36.
36. But the amount is at page 37, my lord, the DM's order. On the top, first paragraph.
17 lakhs
68,000 and odd. My lord, this is, my lord, subsequently this figure of 1 crore has been reduced to 20 lakhs. This has been reduced. Why I am saying so? Why I am saying so? My lord kindly takes up page 45.
Did it rise up to 1 crore?
It was issued in 2016 as 1 crore, but during the COVID, it was reduced to 20 lakhs. It was reduced.
Show me.
My lord, kindly takes up page 45. In exercise of the, it is dated 24th of February 2020. In exercise of powers, same averments, my lord. Even the mother notification dated 5th August 2016 is there. A fourth line from above. It's there.
Oh, 20 lakh, it has come down.
Come down. It's come down to 20 lakhs. My lord, even in 20 lakhs, my dues are
No, but then you show 17.
17. My lord, this is after
Fine,
application of interest. My original dues loan was 12 lakhs and odd.
So after 17, nothing could be added because NPA.
Yes, NPA.
So nothing.
My lord, the dues, the original, the amount which should be reckoned is the amount which has been financed, not the due. Because after application of interest, it might be 25 lakhs.
Yes. Securing repayment of the secured debt with principal amount of ₹1 crore. Yes, please, bank.
But two things. First is the physical possession of the property has already been taken. Now, there would arise a question of the maintainability of this application. But insofar as the applicability of the notifications are concerned, this is a housing finance company. But strictly speaking, the housing finance company does not fall under the category of non-banking financial companies as it is considered under this notification. But I'll have to come back to your lordship on this point, whether I am covered by this notification or not. A clear reading says that I am not covered, but I'll still come back to your lordship and do some further research and say whether I am covered, I fall under this or not.
My lord,
and this petitioner had written to the bank, written to me, alleging this, and this has also
No, I had written to the Reserve Bank. I had made a complaint to the Reserve Bank, which was replied to by not by the Reserve Bank, but by the respondent financial institution.
That is what I'm saying.
The Reserve Bank a party over here?
Yes, my lord. Reserve Bank, Department of Financial Services.
They are a party.
They are party.
They are a party.
They are parties, my lord.
Sir, one more notice also. Please come.
My lord, may I make one humble submission?
Yes.
My lord, the possession has already been taken over by them. It is with them. They are secured. My lord, if today a sale notice is issued and the property is sold, my lord, this writ petition will become infracted.
Wait, it is pending from October. All on a sudden, why are you making
No, my
this
lord,
submission?
I have an apprehension why I am saying so. My lord, tomorrow they might issue a sale notice. They have
Let us see.
Keep it as soon as possible. My lord, we'll come back.
Matter is there in the list. From October, you were not apprehensive. When the matter is taken up, all on a sudden you say it may, they may.
I was before your lordship. I was.
So you are still before the court.
My lord.
Acha likhun to.
Acha non-mortgage.
None represents the. Who is this respondent number 3? Department of Financial Services, Ministry of Finance?
Yes, my lord, the notification has been issued by the Ministry of Department of Financial Services, Ministry of Finance.
No, but this is the central government, the Union of India, Department of Financial Services. Only Department of Financial Services cannot be a party. Achanan represents the respondent numbers 3 and 4. Let further notice be issued upon the non-appearing respondents, intimating that the matter will appear in the list on 11th of February.
Any day.
Stop. Learned advocate representing the respondent numbers 1 and 2.
1 and 2.
Shall revert with regard to the application of the notification at page 45 of the writ petition. Stop. The non-appearing respondent shall also intimate the court with regard to the applicability of page 45 on the respondent numbers 1 and 2.
My lord.
Grateful.
My lord.
Service is taken on record.
One humble.
Union of India, you serve at
Yes,
11th
right,
Strand
sir.
Road. 11th Strand Road, serve.
I'll serve it.
And the Reserve
only
Bank.
one submission. There are some unmortgaged properties like clothes and educational qualifications of my daughter. My lord, those are required. Upon their usual undertaking, let them videograph it. Let them take a panchnama. My lord, I should be allowed to remove those. Those are my goods. They are not mortgaged.
From October till
Those
January.
educational qualification, those documents are required.
Required. 2 weeks you wait.
Grateful.